Distinși invitați, onorat auditoriu, bun venit la Constanța, bun venit la Facultatea de Drept și Științe Administrative din cadrul Universității Ovidius din Constanța. Realizarea unei proceduri simple și eficiente, de la obținerea titlului executoriu și până la executarea acestuia, nu este doar titlul conferinței care se va desfășura în zilele de 5 și 6 în această locație, ci, în esență, este vorba despre studierea unui întreg mecanism procesual și procedural deosebit de complex, din punct de vedere legislativ, doctrinar și, bineînțeles, jurisprudențial. Procedura civilă modernă recunoaște principiile procesului echitabil atunci când ne referim la activitățile specifice procesului civil, indiferent că ele se desfășoară în faza de judecată sau în cea de executare silită. Tocmai de aceea, pe parcursul acestor 2 zile, vom audia teme de o importanță specială, atât din punct de vedere teoretic, cât și practic, motiv pentru care profit de această ocazie pentru a mulțumi tuturor speakerilor înscriși la această manifestare. De asemenea, consider util să reamintesc faptul că lucrările acestei conferințe se vor desfășura în limbile engleză și franceză, tocmai pentru a respecta cu strictețe un criteriu esențial CNATCU, un criteriu de calitate specifică organizării unei conferințe internaționale. Doamnelor și domnilor, acțiunea de astăzi este rodul unei colaborări impecabile între Facultatea de Drept și Științe Administrative din cadrul Universității Ovidius din Constanța, Uniunea Internațională a Executorilor Judecătorești, Uniunea Națională a Executorilor Judecătorești din România și Camera Executorilor Judecătorești de pe lângă Curtea de Apel Constanța, cărora profit de această ocazie să le mulțumesc și pe această cale. De asemenea, mulțumiri partenerilor noștri media, juridice.ro și, în egală măsură, editurii Larsie din Belgia, pentru oportunitatea pe care ne oferă în ceea ce privește publicarea volumului conferinței. Doamnelor și domnilor, astăzi este o zi importantă, este ziua educației, 5 octombrie, și astrele s-au aliniat în așa fel încât la Constanța să se desfășoare această activitate științifică, care, veți vedea, va prezenta un interes special atât pentru doctrinari cât și pentru practicienii dreptului. În continuare, o rog pe doamna președinte a Senatului Universității Ovidius din Constanța, profesor universitar dr. Diane Vancea, să vă adreseze un cuvânt de bun venit.
Vă mulțumesc foarte mult. Reprezintă o onoare pentru mine ca în numele Universității Ovidius din Constanța să vă urez bine ați venit la Constanța într-o zi frumoasă cu soare, benefică pentru lucrările conferinței dumneavoastră. Am mai spus-o, dar îmi place să o repet. Dumneavoastră, Dumnezeu v-a dat sau v-a împărțit o parte dintre calitățile sau atributele specifice, aceea de a face dreptate, de a judeca. Prin exact acest partaj pe care l-a făcut cu dumneavoastră, ca oameni, cred că v-a îndumnezeit. Mi se pare un lucru absolut emoționant, pentru care vă invidiez, eu fiind economist, dar și vă și compătimesc în același timp, pentru că este extrem de greu, extrem de dificil să îndeplinești acest act de justiție. De la primul până la ultima, de la prima act
from the very beginning to the last one. As far as I can tell, we have people that are here with us that are in charge with keeping the rule of law. And our focus today is the most difficult part. I can speak out of my experience because enforcement is one of the most difficult processes in law. I have spent hours and hours together with my colleagues to find the right court decision together with them. Our dean, who has invited you today, knows what I'm talking about, being a member of the Senate, as I am. I have now the opportunity to ask him to bring into discussion the court decision that we had to enforce. And I really hope that the solutions that you will find will be beneficial to us all. We are in the position to learn step by step some of the elements that are related to applying legislation. The Senate of a university is the highest forum of a university where activities are happening, methodologies, and without being specialists, we might face difficulties. But with your help, through your contribution, through your efforts today, through your research, you are definitely going to help us to fulfill our duties to be just and unbiased in our society. Thank you very much for being here. May I congratulate our dean for this event, for the topic that was chosen, for prestigious contributors today. I wish you all a pleasant event, and I cannot wait to have the enforcement process as simple as possible to support justice and a right cause for our society. Thank you very much. May you have a wonderful day. Thank you very much, Mrs. President. Mr. Bogdan is going to welcome you and say a couple of words as an introduction. Good morning, everyone. Thank you, Professor. The Union of Judicial Officers is honored today our topic is very important. This is desirable to transform the enforcement process to make it easier and more accessible. We have in terms of digitalization, the aim of making the procedure easier and more efficient. We can already enjoy some of the results that were granted by digitalization. This is great news because some of the stages are eliminated. All these things are not enough though, because we really want to have a fruitful collaboration with other institutions. We have to also consider a legislative framework that can guarantee the electronic documents to be accepted, granted, approved. We are very optimistic in this respect because we do have support from other institutions. We want the ability of the judge to sign electronically because this is going to support the speed of the process. But the digitalization is not the only challenge. We do want a collaboration. By that I mean courts that have to shorten the terms. We also have a project where we are partners with the Ministry of Justice that is going to be implemented at the beginning of the next year. The stages of the project are quite advanced. And it refers to eliminating the classical communication and shortening of stages, a procedure that is going to be proceed digitally. As for the judicial officer to be able to communicate with the courts only digitally in order to obtain enforcement and other documents. So the topic is a very actual one. We are really looking forward to find solutions as to be able to work on a procedure that is faster and more efficient. Thank you and enjoy your day today. Thank you very much, Mr. Vice President. Mr. Judicial Officer Mark Schmidt is the President of the International Union of Judicial Officers, is going to say a couple of words to you.
And also thank you for the member of the Scientific Council to be here in Constanța.
We are happy to nous sommes très heureux de vous avoir ici et aussi
So, Honorable Chairwoman of the Legal Committee of the Senate, Honorable President of the High Court of Cassation of Justice, Honorable Prosecutor General of the Constanța Court of Appeal, Honorable President of the Constanța Court of Appeal, Director of the Ovidius University of Constanța, dear Dean of the Faculty of Law and Administrative Science, dear professors, dear colleagues, ladies and gentlemen. So first I would like to warmly thank the Ovidius University of Constanța and especially the Dean of the Faculty of Law and Administrative Sciences, Professor Adrian Stoica, for the organization of such a high-level conference and, of course, for having associated the UIHJ to this event. The participation of the whole UIHJ board, as well as of the Scientific Council of the UIHJ, and as you might know, Professor Adrian Stoica is a member of it, in this Congress testifies to the excellent relations which reign between the International Union of Judicial Officers and our colleagues in Romania. The UIHJ, which celebrated its 70th birthday last year, is now undoubtedly one of the largest professional associations in the world, with its 103 judicial officers, associations and chambers, as well as state enforcement authorities from a total of 98 countries and 5 continents. And we are very proud to have our Romanian colleagues with us since May 2000, when the National Chamber of Judicial Officers of Romania became a member of UIHJ on the occasion of our International Congress that has been held in Athens. Furthermore, we are also very proud of the signature of a cooperation agreement on 3 April 2014 between UIHJ and the Faculty of Law and Administrative Science of the Ovidius University of Constanța, cooperation agreement which provides in its Article 2 the joint organization of conferences such as this one. Today we are here at the opening ceremony of a conference on the making of a simple and effective civil procedure from obtaining an enforceable title to its enforcement. And in this context, it is indisputable that the judicial officer plays a very important role and that justice without judicial officers is simply not imaginable. The role of the judicial officer is an overall thread running through the whole stages of the civil procedure, and it already starts with the institution of the process through the service of the summons to appear in court by him. So serving a summons to appear in court by a judicial officer is important to ensure that the legal process is carried out correctly, fairly, and in accordance with the law. It helps to protect the rights of all parties involved and maintains the integrity of the judicial system. Nevertheless, we must observe that judicial officers have only in some countries this competence, mainly in those where the judicial officer is acting under the umbrella of a liberal status. The judicial officer can also play a role during the trial itself, mainly when it comes to the administration of evidence through statement of facts that can be carried out by them, even if I must admit it, in unfortunately only a few of countries. The administration of evidence through statement of facts is undeniably a competence of the judicial officer that must be developed and be set much more in the focus. Statement of facts are offering legal certainty in a very simple, efficient, and cost-effective way. They allow to accelerate a trial and are not underestimate element of establishment of truth. And of course, there is the role that judicial officers are playing after the trial, when it comes to the enforcement of the court decision. I would call it the core business of judicial officer. We all know about the fundamental role that the judicial officer is playing in that respect. What would be the value of a judgment if it cannot be enforced effectively, even not the paper it is written on? And today, a well-functioning society requires an independent, impartial, and efficient judiciary. And together with the judge and the lawyer, The judicial officer is one of the three fundamental pillars in every judicial system. But nevertheless, we are standing at the beginning of new challenges, especially when it comes to digitization of justice in general, but also to digitize
Aujourd'hui, une société qui
as well as enforcement on digital assets. If the use of new technologies can certainly be a powerful tool in the accomplishment of our daily tasks, they can also, if we are not cautious, constitute a danger for our very existence. The judicial officer must, at all costs, demonstrate that he is the enforcement professional and that it is his knowledge and especially his human factor that allows him to position himself in the judiciary of the future. UIHJ is ready and willing for this challenge and support its members in every possible way. And in that respect, the strategy to be followed is to emphasize the fundamental role of the judicial officer in enforcement. He's always the first and often the only contact between parties in the judiciary. In that respect, the judicial officer will always play a key role, and as he's the only one operating in the field. And as such, he's the best qualified and able to evaluate each situation much better than any algorithm in the world. Judicial officers can be considered as a safeguard of human rights and as an essential element of the rule of law. Judicial officers are without any doubt a trusted third party and contribute in a considerable way to a simple and effective civil procedure. The judicial officer, the trusted third party, this is also the topic of the next International Congress organized by UIHJ from 8 till 10 of May 2024 in Rio de Janeiro in Brazil. It is without any doubt that the social role and the human character of the judicial officer will play a central role in the discussions. And at the same time, and as a follow-up of the International Congress of Madrid in 2015, where the UIHJ Global Code of Enforcement has been presented, and the International Congress of Dubai in 2021, where the UIHJ Global Code of Digital Enforcement has been presented, the Congress of Rio will allow us to present a code of international professional standards where ethics will play a central role. Participants will have the unique opportunity to meet and to exchange with judicial officers from all over the world. Be a part of this amazing event that is organized only every 3 years and that can be considered without any doubt as a highlight in the professional life of judicial officers. Rio de Janeiro is waiting for you. To conclude, let me now wish to all of us a very successful and productive conference here in Constanța. I am convinced that it will for sure exceed all expectations and become a memorable event. Thank you very much for your attention.
Thank you, President. Thank you for your presence here. Thank you, International Union of the Judicial Officer, for that great cooperation. În continuare, îl voi ruga pe domnul procuror general al parchetului de pe lângă Curtea de Apel Constanța, domnul procuror dr. Gigi Valentin Ștefan, să ne adreseze un cuvânt în deschiderea acestei manifestări.
Mulțumesc! Bună ziua tuturor! Vreau să vă spun că sunt onorat de a participa la această conferință și să mulțumesc pentru invitație. Știu că se va ridica la cele mai înalte standarde profesionale. Vreau să transmit salutul și urările de bine tuturor invitaților și participanților și să le doresc o ședere cât mai fructuoasă și interesantă la Constanța. Aș vrea totodată să apreciez activitatea organizatorilor care au demonstrat încă o dată, deși nu mai era cazul, că prin toate acțiunile lor contribuie în mod semnificativ și evident la creșterea prestigiului Universității Ovidius. Aș vrea de asemenea să remarc colaborarea deosebită pe care o avem cu conducerea Camerei Executorilor Judecătorești Constanța și să remarc modul și caracterul impetuos, transparent, obiectiv al acțiunilor acesteia de la începutul mandatului. Legat de tema conferinței, vreau să vă spun că am cunoștință de o serie de considerații, aprecieri cu privire la formalismul excesiv al procedurii executării silite din noul cod de procedură civilă. Și din solidaritate vă spun că toți ne dorim o procedură civilă, respectiv penală, cât mai flexibilă, cât mai fluentă, care să contribuie la eficientizarea activităților noastre.
Proceed with our tasks. New codes of penal procedure are subject to new transformations, and they were affected by these documents, and thus our activity is also affected by these modifications. What can we do for becoming more efficient in our work? To think about proposals, to fight for legislative modification, transformation. And in this context, the topic of this conference is more to be appreciated. Only with these changes we are able to become more efficient. I would also like to end my speech with a well-known quotation. You have to make the reality that you see ideal, and to make a real the reality that you feel. This is a quotation selected from Alexandre Dumas's writing. Thank you very much, and may you have a fruitful event. Thank you very much for your intervention. May I congratulate on your French as well. May I introduce Mrs. Judge Alina Gabriela Jurbiță, President of Constanța Court of Appeal. She's going to talk to you and to introduce our conference. Thank you very much. Good morning. You might already know that I'm a constant presence, and as I always do, I prepare a speech, and then I change and I adapt my speech according to the context. You may call it creativity, you may call it adapting to the context. I have prepared my speech in English, but I'm gonna speak. I'm gonna deliver my speech in Romanian today. The proposal of Faculty of Law honors me, and I have to welcome you as well, and to express my gratitude to those organizing the event. I have researched the topic of enforcement, and even from the beginning of times, these aspects have been studied, or they were challenges for all those in charge. In Hammurabi's code, we have the problem expressed. Enforcement in our modern society became a subject in law schools later. We are really trying to digitalize, all the processes. We do not know if the procedure is extended to our entire country, but in Constanța, we are really working towards having digitalization in our work. And this is a huge benefit for all of us. We are really supporting the electronic documents to be approved, because it saves time and it helps us in our work. We also want to keep good work relationships with all those involved in the process of law. The enforcement, as well as the trial, is a very complex activity that involves everybody, judicial officers, prosecutors, and all those parties that are involved. But because we as a society are permanently changing, we also need to adapt these procedures to the changes of our society. As a judge in Constanța Court of Appeal, in all my career, I have dealt with such claims related to enforceable titles or enforcement. And in this respect, such events are beneficial to parties involved, for practitioners, for theoreticians. I think I'm gonna stop here with my speech. I'm really positive that the following presenters are gonna approach the topics in more detail. Once again, may I thank you for being here, for delivering this speech. May I also congratulate all the participants. May you enjoy this conference, and may it be fruitful for everybody. Thank you very much, Mrs. President. I'm going to ask Mr. Judge Corina Alina Corbu, President of the High Court of Cassation and Justice, to deliver her speech. I would like to thank her very much for her presence here. It's a huge honor. It is indeed for the first time when a president of the High Court and Cassation and Justice is together with us at Constanța. Thank you very much. We know that you are very busy. Thank you for granting us the honor to be here with us at the introduction of this conference. Thank you. Dear participants, dear colleagues, dear participants, dear ladies and gentlemen, thank you very much for this wonderful presentation. I would like to thank the Faculty of Law and Administrative Sciences for this opportunity to be here today with you. A very special day, 5th of October, the Day of Education. And may I say that education is crucial for the development of our society. May I talk about a project that has been important for all those law practitioners, education. It is for the first time when presidents of the High Court of Cassation and Justice are involved. We are very trustful in this project because we want to develop our society in this respect, in the respect of education as well. May I also congratulate on the importance of the topic that you have chosen. I won't consider technical aspects. I have seen the presentation, so I'm gonna limit myself to send you my gratitude and my thoughts. Our society has grown to be more involved in its problems, and the judicial system has to consider the involvement of our citizens. I have seen that as a judicial manager. I have seen that with my position as a judge and considering the professionals of all my colleagues involved in the process. And I have seen it in all the initiatives that refer to collaboration between institutions. I believe that we are closer than ever to the moment when politicians, law professionals, civil society, when we can actually proceed with a common project in terms of educating our society. And I don't think it only has a national component. It has an international and especially an European component. And previous speeches have only supported my point of view. For keeping the word of justice, it is important to keep all procedures efficient, simple, and transparent. Efficiency is quite crucial. As well as the quality of the procedures, enforcement procedures. The way we approach all those processes is a problem as complex as you might consider it in our system. one of the toughest decisions for a judge is to choose between the quality of his decision, which is actually his signature, and the ability to motivate within the time frame granted by law. This is why we have to make efforts as for judges not to be forced to choose between the two of those. We shouldn't be choosing between quality and quantity. We have to make sure that judges are involved, they are motivated, they are unbiased to be able to cope with their missions. But all efforts are useless if we don't have the methods that are right. For example, the judicial officer to proceed with less effort, with more transparency and more efficiency. What is actually happening after the process is as well as important as what happened during the process, the court trial, the lawsuit. Therefore, a question arises: how can we develop the efficiency of judicial processes, and how we can ensure the fast enforcement and the transparency of it? I'm pretty convinced that you are going to try to find answers for all these questions. In my opinion, the answer is to be found in institutions, in those institutions that are involved in deciding, state institutions. They have to keep their prestige, they have to keep their efficiency, the process of the digitalization. They have to continue to collaborate better and to respond to society's needs. An event such as ours today is only supportive in this respect because it points to collaborating through these institutions and all those involved. I would also like to underline the fact that ensuring a very simple and efficient processes doesn't only have a direct effect on justice. It also has an indirect result. Alternative solutions are stimulated through these processes. Commercial relationships, civil relationships are to be considered as well. Thus, I wish you all success in identifying the above mentioned goals. Thank you all very much. Thank you very much, Mrs. Judge, and we are very happy to have you here today. May you be successful and efficient in your career. May you have good health and be motivated to work. Before we finish this first part of our conference, may I offer you some materials meant to promote our university. Thank you for being here once again. May you have great success with your careers and your projects in your careers.
Mulțumim frumos și acum vă invit la o...
Thank you very much. May I invite you to take a short break? Good morning, everyone. May I apologize for not being here. May I also wish welcome. It is also nice to see you here again, once again. I'm so delighted that I see friendly faces of people that have been with us before. A very special moment in our conference. A reason for celebration is granting the title of Doctor Honoris Causa because the proposal has been has been made by the Faculty of Law. May I invite the Dean of the Faculty to deliver his speech. May I, with your permission, continue this introductory part?
De Constanța.
Esteemed Rector of the Ovidius University of Constanța, distinguished Madame Professor Frédéric Ferrand, honorable audience, it is with great pleasure and honor that I open this festivity, held on the occasion of bestowing the title of Doctor Honoris Causa by the Ovidius University of Constanța to the exceptionally gifted professor of the Université Jean Moulin Lyon 3 from France, Mrs. Dr. Frédéric Ferrand.
Il s'agit d'un moment.
This is a very special moment, not just because the person that is about to receive the honor is one of the most important figures in the field of civil procedural law in Europe and beyond, but also because this title is one of the most prestigious distinctions offered by universities in Romania. Chronologically, European University began awarding diplomas for honor's sake, honoris causa, in the 15th century. And the first such diploma was awarded by the University of Oxford in 1478 to Lionel Woodville, Dean of Exeter, brother-in-law of King Edward IV, and future Bishop of Salisbury. These were essentially academical knighthoods, granting the beneficiary full privileges within the university, privileges which were significantly larger than today. Thus, returning to the academic personality of Madame Professor Dr. Frédéric Ferrand, one must recall that all her contributions to education and research have been extremely appreciated, both in France and Germany. From 1981 to 1983, she was assistant researcher at the law school of the Augsburg University, as well as internationally. Throughout the years, she has received a great many distinctions, among which the Prize of the Association of Doctors of Law, Lyon Chapter, 1991, Second Prize of the Centre Français de Droit Comparé, 1991, Knight of the Legion of Honor, 2010, Officer of the Palme Académique, 2019. Also known for exceptional editorial, scientific, and teaching activities, Professor Dr. Frédéric Ferrand represents an authentic model which inspires students and young professionals alike. For the academic community of Ovidius University of Constanța, conferring this title signifies, on the other hand, an acknowledgement of the complex personality of Professor Dr. Frédéric Ferrand. And on the other hand, joining the group of honorary doctors of our law school, which includes eminent members, notable in the field of legal sciences, such as Professor Dr. Honoris Causa Nathalie Frisereau, who is also present now, Professor Dr. Honoris Causa Ioan Leș, Professor Dr. Honoris Causa Marin Voicu, Professor PhD Honoris Causa Marin Duțu, and so on. As such, the decision of the Senate of the Ovidius University of Constanța to confer its highest distinction to Professor Dr. Frédéric Ferrand must be welcomed and particularly appreciated. At the same time, we congratulate Madam Professor for the conferment of this title and wish her the fullest of success in all her future scientific endeavors. Vivat, crescat, floreat. Noster magister.
În continuare, voi trece la limba română și îl voi ruga pe profesor universitar dr. honoris causa Ioan Leș, membru al comunității academice ovidiene, să îi prezinte laudatio doamnei profesor Frédéric Ferrand. Domnule profesor, aveți cuvântul.
Monsieur le recteur, Monsieur le doyen, chers collègues, mesdames et messieurs, c'est un grand honneur pour moi de présenter aujourd'hui ici, à Constanța, quelques considérations sur l'activité professionnelle de Madame le professeur Frédéric Ferrand. Il est professeur à la faculté de droit de l'université Lyon, Jean Moulin, Lyon 3, con titre de professeur exceptionnel échelon 2. Pour moi, c'est un peu difficile de parler d'une grande personnalité, non seulement du droit français et du droit européen, et même, je pourrais dire, du droit international. En lisant son curriculum vitae, j'étais très impressionné pour sa activité très riche, très vaste, et qui couvre non seulement
very vast activity that covers not only the judicial domain but also other branches of law. I asked myself, by reading the CV of Madame la Professeure Frédéric Ferrand, where does this enthusiasm come from? I hope I am not wrong. It is about consistent work and passion. Passion towards the civil procedure. Maybe it's a little strange, but why? Love, passion for civil procedure. Here in Romania, we believe that the procedure is mathematics. But I remember a very important French professor, Serge Michard, who was teacher, Mrs. Ferrand's teacher, and also the Dean Jean Vincent, who in a book called Civil Procedure, they said that the civil procedure is it's a very complex procedure, which is the appanage of some of the lawyers. The procedure is a discipline, a subject that we can find in all law schools. Without procedure, the law isn't sufficient, isn't enough. Because when there is a problem, the justice must intervene, and consequence civil procedure. I also remember very well when I was a professor, acting professor. I loved presenting to my students during my first discourse a few aspects on the importance of civil procedure. And I also remember that my professor had cited in their book, Civil Procedure, that everything is procedure. And the 20th century will be procedural, and it won't be. Of course, this is an exaggeration, but it's about an exaggeration that illustrates in an excellent way the importance of civil procedure. And we are here in a conference which regards forced execution. Here we have an excellent paraphrase of the former minister Charles de Gaulle. D'André Morin, a very distinguished professor, who said that the 21st secle, 21st century will be religious and it will not be religious. He did not talk about a religious century, but a spiritual century. Here it is. And now I believe that this is where this extraordinary work comes from. I'm telling you that for me it's very difficult to present her whole didactic and scientific activity. But how we have the how we are accustomed to talk during the honoris causa ceremonies, we should talk about Professor Ferrand's scientific activity. She works today at the University of Lyon in France, and she is very well appreciated. She is appreciated by her students, by her PhD students, by her colleagues from University Lyon 3, Faculty of Law. She has illustrated in an excellent manner her whole didactic career. But what I would like to underline is the fact that Mrs. Professor Frédéric Ferrand has illustrated not only the civil procedure, she's also had courses and conferences on different other subjects, for example, civil law, family law, and even she had some interesting conferences for a professor of law, judicial law, like, for example, considerations on German law, on the law of minors, on the participation of minors in the German trials, and also conferences on the Court of Cassation. She's also published articles And I think, the Dean, that we should organize a whole conference, full conference, to present the whole array of work of Mrs. Ferrand. And I'm going to explain myself. If we are talking about the professional activity of Professor Ferrand, we are obliged to talk about all her activity, because she has embraced all the institutions, judicial institutions. From France, and all the institutions that belong to the organization, the judicial organization, of course, including forced execution. So I'm going to limit myself to talking about a few of her articles, and to underline the fact that she published also in Argentina, in Brazil, and in Italy. But talking about these articles, I can't avoid saying something about some of her very important articles, not only for French doctrine, but also for us here in Romania, for all the ones working on doctrine in Europe, because I want to talk about an issue which is very present nowadays. For instance, I'm taking into account the appeal, the reform of different procedures, such as filtering procedure. I can't talk about what happened here in Romania, the Constitutional Court. He, for example, said that the filtering procedure is not constitutional. Very curious, in my opinion, because that procedure, which is perfectly constitutional in France, is not constitutional in Romania. Today we will talk about other similar situations. Professor Ferrand has written a lot, and she published very interesting books for doctrine and for the French doctrine and jurisprudence, case law. I want to say that she published very interesting books together with Professor Michard, who, if I understood well, was her teacher. And they published together books consecrated for civil procedure. The last edition was published in July this year. I could also say something about the book, The Doctrine and Jurisprudence in French Law, which was published which was also published under the coordination of Professor Michard. And Professor Ferrand had a very important contribution in which is concerned the European competence and the execution of cross-border judgments. There are many things to say, but time flies by, and we are always pressed by time. Before concluding, I would like to say that we are in the presence of a great personality of French law, of European law, and of international law. And for this, it's a great honor for me to speak here today about Professor Frédéric Ferrand. And we should all be honored for the fact that Professor Ferrand was received in the great family of Dr. Honoris Causa of Ovidius University. Considering all of the above, I am very happy to participate in this important event. I congratulate Professor Ferrand. I hope she will have strength to continue her research in criminal procedure. I would also like to thank the rector and the dean for inviting everyone to participate in this ceremony, and I would like to also thank all of you for the courage and for the fact that you are patient and to listen to me. In the language of Voltaire and of Victor Hugo. Thank you very much, all of you. The Dean would also like to thank all of you and Professor Leș for this very interesting presentation. You mentioned Professor Frédéric Ferrand and Professor Nathalie Frisero. They participated together in 2007 in the week of compared law in the section for Romanian civil procedures, and Professor Frisero and Professor Ferrand and Professor Sergei Shah brought very good solutions in order to have a civil procedure code very clear and efficient. Next, the second person who will have to present their laudatio to Madame Professor Frédéric Ferrand was Professor Honoris Causa Marin Voicu, but because of an accident, of a domestic accident, he gave me the go to make a synthesis of his laudatio. Of the laudatio he prepared for Professor Frédéric Ferrand. Dear Rector, dear colleagues, dear students, we gathered here today on the 5th of October to enrich the club of Dr. Honoris Causa of Ovidius University. It is the merit of the University Senate and most of all of the Dean of the Faculty to successfully persevere in the excellent organization of such scientific feasts. We take pride in the members of Dr. Honoris Causa Club. Professor Voicu has grouped this laudatio on a few considerations on the members of the club Dr. Honoris Causa, which exist at this point within the Faculty of Law of Ovidius University of Constanța. He also observed the evolution of the academic evolution of Professor Ferrand. He also made a selective overview of the academic results of Professor Frédéric Ferrand. underlining the main articles and contributions, which have a remarkable number. He also pointed out the contribution of Professor Frédéric Ferrand in which concerns European law, and also her personality and academic and professional qualities. Professor Marin Voicu has also underlined some of the conferences Professor Ferrand Madame Ferrand, where Professor Ferrand participated. Here is an overview. Some of the considerations that why we support the conferment of the title of Doctor Honoris Causa to Professor Frédéric Ferrand. Professor Marin Voicu is an honorable member of the Academy of Juridical Sciences and president of the section of International Law and Compared Law. He is an associate professor with the Faculty of Law and Administrative Sciences of Ovidius University of Constanța and judge in the Constitutional Court of Romania, and first judge in the panel for human rights. This is a synthesis of his laudatio. And now, Mr. Rector, you have the word.
Și ce rectorul acum ce ne spune?
Nu știu, dar nu se aude.
Și pe asta cine zice?
Nu știu.
Madame la professeure,
Dear Professor Ferrand, today you become a Doctor Honorary Doctor of Ovidius University of Constanța. Along with the I have the honor of showing your career and your personality, of talking about your career and your personality. There are a lot of reasons why we decided to confer this title to you during this ceremony. I will first talk about the importance you have in our eyes, that you became a member of the scientific committee of the International Union of Judicial Officers. During a conference, you attracted the attention of one of our colleagues. And then you were part of the work group for civil procedures, which was published in 2004. For several years, you worked on transnational litigations. The text you developed is that it's the basis of future reforms, national reforms. The International Union of Judicial Officers remarked the innovatory character of this document, And we are happy that you accepted to guide us and to allow us to reflect on the universal principles regarding forced execution. This is how, with your all your expertise, you participated in 2006 in Washington during our meeting, international meeting in Washington. An approach, a universal approach on execution, forced execution. You have a very deep knowledge of civil procedures and execution, and of that of the profession of a judicial officer. On 21st June 2008, in the Council of the International Union of Judicial Officer, you were one of the 4 founding members, and we can count on you for, we've been able to count on you for 15 years. Thanks to your experience, we were able to finish our work and to publish in 2015 the International Code of Execution, and then of the International Code of the Digital Code of International Execution. You participated to the works of the Scientific Council, working on world rules on deontology and ethics. During these 15 years, when you were a part of our scientific council, you were a very important source of inspiration, and you are very appreciated by everyone. That's why the members of the Scientific Council of the International Union of Judicial Officer have come from different states, such as the Netherlands, the US, Italy. So I would like to say, from the part of everyone who is present here, all the members of our union, and to address our congratulations for the distinction of Dr. Honoris Causa that you will receive today from Ovidius University of Constanța. Congratulations.
Nu am mai văzut.
Dacă mai dorește cineva să...
Is there anyone else who would like to say a few words? No,
say
okay.
a couple of words.
In that case,
If not,
I have the
I
pleasure
have the pleasure to
of reading the committee for the award. President of the Senate, Professor Paul Evancea, PhD, the Dean of the Faculty of Law, Professor Adrian Stoica, Professor Ioan Leș, Dr. Honoris Causa of Ovidius University of Constanța, and Professor Dr. Honoris Causa Marin Voicu, Dr. Honoris Causa of Ovidius University of Constanța.
Professor Diane Paula Corina Vancea, President of the Senate, Professor Adrian Stoica, Dean of the Faculty of Law and Administrative Sciences, Professor Ioan Leș, Emeritus Professor of the Faculty of Law, Lucian Blaga, University of Sibiu, Affiliate Professor of the Faculty of Law and Administrative Sciences, Marin Voicu, Ovidius University of Constanța.
Honorificum Institutii Universitarii Franco-Gallici, quiam totas annis diligentem assiduamque in novo codice Daco Romano processuali de iure civili conficiendo, et in studis iuris processualis Franco-Gallici et iuris Unionis Europee operam navat. Doctor honoris causa declararetur, in cuius rei fidem hoc diploma sigilio huius universitatis signatum nec nom subscriptum manu rectoris eiusdem conscribendum censuit. Datum Tomis ante diem tertium nonas octobres anno Domini bismillesimo vicesimo tertio.
Monsieur le recteur,
Dear Rector, dear Dean, dear colleagues, doctors, students, I'm addressing you with honor for having been named Doctor Honoris Causa. A beautiful ceremony whose recipient always wonders if he or she really deserves the recognition thus granted to him or her. Let us hope. Thank you for this ceremony, which puts us in academic Europe. This conference, organized together with the International Union of Judicial Officers, shows that it's essential to enrich our practices with the experience of other colleagues from other countries. It is about this Europe that I would like to say a few words to you about, from the angle of the importance of mutual trust in judicial cooperation and the challenges it faces. Europe, in the sense of a project which brought together founding states, then grew gradually. The European Union, as it is called today, develops judicial cooperation in civil matters with cross-border implications, based on the principle of mutual recognition of judicial and extrajudicial decisions. Such cooperation also exists in criminal matters. It is the mutual trust expected, even required, between member states that I wish to discuss with you. It was first imposed on the internal market, for example, in the terms of recognition of diplomas and freedom of movement. And it was elevated to the level of constitutional level in Europe. Elevated to the rank of constitutional principle, as one of our authors, Stephanie Frank, wrote, it is the foundation, the axiomatic principle of judicial cooperation, be it criminal, both criminal, the flagship example is the European arrest warrant, and civil matters, for example, in the context of the free movement of court decisions with the elimination of border effect. It could be affirmed that this confidence was in danger, threatened by the blow sometimes dealt to the base values which presided over the both of the community, then of the European Union, values brought together in Article 2 of the Treaty of the European Union, which states, the Union is founded on the values of respect for human dignity, freedom, democracy, equality, the rule of law, and respect of human rights, including the rights of persons belonging to minorities. These values are common to the member states in a society in which pluralism, non-discrimination, tolerance, justice, solidarity, and equality between women and men prevail. So why trust? As stated by the Court of Justice in its opinion 2 by December 18, 2014 on the accession of the Union to the European Convention for the Protection of Human Rights and Fundamental Freedoms, the principle of mutual trust between member states is of fundamental importance in EU law. So much so that the court at the time deduced that accession to the convention would require considering the Union and the member states as contracting parties, not only in the relation with those which are not member states of the Union, but also in the reciprocal relations, including when these relations are governed by Union law, and would require a member state to verify respect for fundamental rights by another member state, even though the Union law imposes mutual trust between these member states. So that accession is liable to upset the underlying balance of the EU and undermine the autonomy of EU law. We will nevertheless recall that Article 6.2 of the Treaty of the European Union requires the Union to adhere to the European Court of Human Rights, and we will note that with interest that things are moving on this point since negotiations have resumed. As part of its commitment to the state de jure, the European Commission decided to relaunch the process and informed the Council of Europe in October 2019 that the European Union was ready to resume negotiations on its accession to the Convention. Formal negotiations resumed into September 2020, and on the 4th of April 2023, with the framework of the Steering Committee for Human Rights, the negotiation group 46+1 presented its report, which contains the drafts of revised instruments of accession. It seems that we are getting closer to a positive outcome, but it will still take time. Once the text has been adopted by the Committee of Ministers of the Council of Europe, it will be open for signing. For the EU, it will require a favorable report from the Court of Justice, an unanimous decision from the Council with the approval of the European Parliament and national parliaments. So there is still a long way to go. Mutual trust is necessary between member states whose bodies, notably magistrates, are called upon to collaborate closely within the framework of judicial cooperation instruments. So each state should correctly apply the law of the European Union. Based on the principle of unity of the union law. These instruments impose said trust. It is a mandatory postulate which is only set aside in the event of exceptional circumstances. Postulate according to which each member state respects fundamental rights, correctly applies European European Union law. This postulate is necessary to guarantee the principle of unity of application of Union law, despite the diversity of national legal systems, and to allow the free movement, in particular, of court decisions, authentic instruments, and transactions. Member states must be treated on an equal footing. The imposed principle of mutual trust prohibits one of them, with exceptions, from judging the quality of the judicial system of another member state and its compliance with Union law. The Grand Chamber of the European Court of Human Rights itself demonstrated a certain self-restraint when it was required to assess the existence of a violation of the Convention. Based on the right to fair trial under Article 6.1, in the case of Avotan versus Latvia in its judgment of the 23 May 2016. The presumption of equivalent protection resulting from the Bosphorus judgment of 2005, which consists of considering that the protection of fundamental rights ensured by the legal order of the European Union is in principle equivalent to that ensured by the Convention, and assuming that the states comply with the requirements of the Convention when they are merely carrying out legal obligations resulting from their accession to the European Union. Has not been ruled out, even though the National Court of the requester member state had contented itself to criticize the applicant for not having contested the decision, while remaining silent on the question of the burden of proof of the existence and availability of remedy in the state of origin. Whereas the Article 6, paragraph 1 of the Convention, like the wording in Article 34.2, in fine, of the Brussels I regulation, requires it to verify that his conditions were met. The European Court considers that this could, in theory, constitute a manifest insufficiently capable of overturning the Bosphorus presumption of the rights of defense, but that due to the particular circumstances of the case, this was not the case, even if this failure is regrettable. So yes, the principle of mutual trust between member states is substantial, with equality between them, with the unity of application of Union law, with the effective creation of an area without borders. Trust is this invisible cement that allows the building to hold together, but it cannot be absolute, and despite its necessity, it is not less subject to risks such as allowing decisions to circulate that violate fundamental principles of rights, the other difficulties and growing challenges. Starting with 2017, the law, especially the Polish one, meant controlling the activity of magistrates. Also authorizing the prolongment of the authorization to be part of a court. So we have a difficulty in which concern the independence of justice. To force the departure of magistrates upholding the rule of law while authorizing an extension of functions by the President of the Republic. In the judgment of October 7, 2021, the Polish Constitutional Court, which is no longer an independent and impartial tribunal today, declared that incompatible with the Polish Constitution the rule of law enshrined in Article 2 of the Treaty for the European Union. Indeed, the court of Justice has developed combative case law based on Articles 2 and 19 of the Treaty of the European Union, as well as Article 47 of the Charter of Fundamental Rights of the Union, emphasizing that Article 19, paragraph 1, paragraph and 2, which sets out the principle of effective judicial protection, targets the areas covered by the Union law, independently of the situation in which member states implement this law. And effective judicial protection requires independent, impartial judges, which certain Polish magistrates no longer are. Those who remain independent use the tool of preliminary reference to the Court of Justice to fight from within to safeguard the independence of justice. Response from the shepherd of the shepherdess: on June 30th, the Polish Supreme Court, in a case concerning the execution of Poland of a judgment rendered in the Netherlands, decided to hold the proceedings and to question both the Polish Ministry of Justice and the Dutch Council of the Judiciary regarding the independence of the Dutch judicial authorities in general and of the magistrate who handed down the judgment to be executed in particular. Referring to Article 2 of the Treaty of European Union, the Supreme Court raises numerous questions on the procedure for appointing judges in the Netherlands. The bodies involved, intervention on or not of the representatives of the legislative and executive powers, conditions under which the judge having ruled in the case was appointed, and even the evaluation made by this magistrate. We can only wonder about the exploitation of this case, which is in itself quite banal, to react in a provocative manner to the judgments of the Court of Justice, noting the absence of independence of justice in Poland. It will be recalled that on June 5, 2023, the Court of Justice ruled on the contrariety of union law of the so-called Polish Mazo legislation, which prohibits any national courts from verifying compliance with the requirements arising from union law relating to the guarantee of an independent and impartial tribunal previously established by law, and makes it a disciplinary offense for a magistrate to carry out such an examination. The principle of mutual trust nevertheless continues to apply to Polish decisions rendered, for example, in matters of European arrest warrant or in the context of the free movement of civil judgments, even through Article 7 of the Treaty on the European Union has been cited against this state. This provision, nicknamed nuclear weapon, which has not been very operational since the second stage, to be triggered requires unanimity of the member states, with the exception of the one which is subject to the procedure. This is provided in Article 1, prevention phase, that the Council, acting by a 4/5 majority of its members, after approval by the European Parliament, may find that there is a clear risk of serious violation by a member state of the values referred to in Article 2 of the Treaty on the European Union. The Article 7 procedure was triggered for Poland in 2015 and Hungary in 2018, without effect until then, its use being more symbolic than effective.
L'incidence au niveau des juridictions de l'État membre.
In matters of European arrest warrant, apart from the exceptions provided for by Framework Decision number 2002-584, in its Articles 3 and 4, the Court of Justice, questioned on numerous occasions by national courts, in particular regarding warrants from Poland, stated its position. It requires the executing judicial authority called upon to decide on the surrender of a person and which has evidence of systemic or generalized failures with regard to the independence of the judicial power or to the issuing member state, with particular regard to the procedure for appointing members of the power, that it carries out a two-step analysis. The first, an abstract assessment of the existence of a risk of violation of the fundamental right concerned, and the second, a concrete assessment aimed at verifying to what extent the failures noted in the first phase are likely to have an impact at the level of the courts of the member state competent to hear the procedures to which the
Sérieuse de violation des droits.
Being particularly complex.
Dans la protection de ces droits.
To cross to refuse the execution of a European warrant arrest. It was nevertheless taken on an extraordinary basis, for example, in a case in which poor conditions of detention in the member state of the European arrest warrant were at issue. Little by little, the Court of Justice has in fact recognized, in the event of exceptional circumstances, exceptions to the principle of trust under the influence of the jurisprudence of the European Court of Human Rights, which, for example, condemned Belgium in a case for having implemented the principle of mutual trust in the field of asylum. In the fight for the rule of law, the Court of Justice and the European Court of Human Rights work hand in hand. So how do you preserve trust? Several ways are possible. As we have seen, it is appropriate to promote the role of both national judges and European courts. The national judges has an essential role, as the European Court of Human Rights emphasized, without, however, drawing any conclusions in the aforementioned 2015 Vatan versus Latvia judgment. The national judge of the requested state, who is asked to declare a foreign decision enforceable, even within the framework of the European Union, is required by the Convention to carry out a control adapted to the seriousness of the situation, serious allegations of violation of fundamental rights in the state of origin, in order to avoid a manifest inadequacy in the protection of these rights. In matters of civil judicial cooperation, this may be done in particular on the basis of a manifest violation of the international procedural public policy of the executive member state, as the Court of Justice has been able to admit in important judgments such as the Kronbach affairs and Gambazzi. In other words, member states should lend their trust without giving it completely, and be welcoming while remaining vigilant. This tool of refusal of execution or exequatur is, however, placed downstream and does not prevent the violation of fundamental rights.
Et là, et les outils se multiplient, espérons qu'ils soient efficaces. Derniers outils en date, 2020, le rapport sur l'état de droit, avec 4 piliers essentiels qui sont renseignés: le système de justice, ce qui nous intéresse au premier chef, le cadre de la lutte contre la corruption, qui peut être lié à l'efficacité du système de justice, le pluralisme des médias et puis l'équilibre des pouvoirs. Et régulièrement, là aussi, la coopération.
The report on the rule of law in the Union appeared for the first time in 2020. Here again, this involves close collaboration between the Commission and the Member States for the collection and analysis of information regarding 4 essential pillars of the rule of law: the justice system, the framework for fighting against corruption, media pluralism, and other institutional issues related to the balance of power. The Commission carries out a qualitative assessment by country, and here again it does not hesitate to formulate individual recommendations whose objective is to help and support member states in the effort they are making. A pragmatic tool which addresses the member state where it is sensitive, financial means, was established by Regulation 2092 of December 16, 2020 on a general regime of conditionality for the protection of the European Union budget, regulation which was validated by the Court of Justice in 2022, judgment following a challenge from Hungary and Poland. The question is not only legal, it is a real in-depth political dialogue which must be intensified both at the institutional level and between member states in order to prevent a rejection of the common values of the Union by certain states from leading to an existential shock for the latter, which was until now enabled the maintenance of peace in the territory it covers. A peace whose still fragile nature has been noted over the past year. Thank you for your attention.
Depuis aujourd'hui, vous êtes plein membre de notre communauté académique.
Starting today, you are a member of our academic environment. Welcome to the body of academic members of Ovidius University of Constanța.
Înainte de a declara închise
Before declaring closed this beautiful ceremony,
the end of this
I would like to invite you all
beautiful ceremony,
to celebrate this new member of our academic community with a cup of champagne.
Celebrate our new member of academic community with a glass of champagne in the hallway.
Good morning, everyone. I'd like to start by saying that for me it is an honor to have been invited to be moderator of this panel and discuss some national procedures in this beautiful city of Constanța, right next to the Black Sea. This topic, or the topic that will be discussed by this panel, is extremely important because it allows us to understand the reality felt by our partners and colleagues, realize their difficulties, but also, and perhaps, their solutions in a clear opportunity for collaboration. Being here today constitutes an opportunity that we must value because it represents an effort by institutions to expose the system's virtues, but also their imperfection and flaws in a collective effort of sharing. As we know, it is undeniable that enforcement procedures are essential for market economy to function at an respecting the rights and guarantees of the parties involved in the dispute. Investment always depends greatly on transparent, strong, and fast judicial systems that can keep up with the pace of evolution. We also must recognize that we live in an era where technological evolution has reached extraordinary levels, and justice must follow this evolution, otherwise it will remain stuck in time and lose importance. One thing I am absolutely certain of is that you didn't come here to, many of you traveling thousands of miles and kilometers, just to hear me speak, especially because I have next to me notable connoisseurs, experienced speakers, and magnificent experts that I am very pleased to present. So allow me the privilege of presenting my speakers. Christine Val, Commissioner of Justice in Toulouse, mediator, president of the Mediation Association of Commissioners of Justice, former member of the French National Bureau, and today member representing France on the board of UIAJ. Jos Out the Hague. Did I say well? First Vice President of the UIAJ. During the past 25 years, Jos has been mainly active as a legal reform and legal drafting expert in numerous countries, both within and outside Europe, mainly in the field of enforcement law, for European Commission, IMF, World Bank, EBRD, USA, ED. Currently active in Western Balkan region, Azerbaijan, Mongolia, Laos, and also EU member states. He has been active as a lecturer at the Dutch University of Applied Science in Utrecht. I don't know if it's right. In Netherlands, Pristina State University, and as a guest lecturer at different universities and judicial academies. He is a reporter of the project Fiduciary Access to Digital Assets of the European Law Institute, was a project member of the Blockchain and Smart Contracts project team, also in the European Law Institute. He is also an observer member of the UNIDROIT project on principles for effective enforcement and observer member of the Commission for the Efficiency of Justice of the Council of Europe Working Group on Cyber Justice and Artificial Intelligence. Ion Les, Emeritus Professor at the Lucian Blaga University of Sibiu, having taught civil procedural law in his university career. He has published more than 30 volumes and more than 200 articles in legal journals in Romania and other countries. In the 90s, he was deputy in the Romanian Parliament and second General Secretary of the government. In the period between 1992 till 1996 and 2004 to 2006, he presented Romania as ambassador to Venezuela, Jamaica, Panama, and Haiti. Now I should be presenting Marian Voicu as speaker, but unfortunately, as you already know, for personal reasons, he cannot be present here with us. So, yeah, yes. So instead, we have with us Professor Adrian Stoica, who will make the presentation on his behalf. Adrian Stoica, Judicial Officer, member of the Scientific Council of UIAJ, and Dean of the Faculty of Law and Administrative Sciences. We also have the pleasure of the presence, Bogdan Dumitrache, pardon, Dumitrache, I'm learning Romania, is one of the most respected judicial officers in Romania and took part in the drafting of the Romania Civil Code. Starting this year, it teaches practical issues in the substantial and procedural civil law, and 3 master's degree program run by the Law School of West University of Timisoara. Is that right? Give applause. Dear speakers, thank you very much for accepting the invitation to be here with us today. Now, let me talk about the rules, because I have rules. First, the speakers will make their presentation, and then, at the end, we'll give way to discussion with audience intervention to ask questions, if there are any questions. Well, we are going to try that. I don't know if we are going to have much time for that. So, we have in global more or less 50 minutes to have your presentations. That gives about 10 to 12 minutes for each and every one of you, so be aware because I will watching the time very carefully. Okay? Now, without any delay, I would like to give the floor to Christine Val, please.
Bonjour à tous.
Hello everyone, I'm very happy to be here. I will talk on the notion of on the execution of decisions in France. I am a justice commissioner in France, in Toulouse, and I practice obviously the forced execution, and I also work on mediation because we realized in France that if the debtor wanted to pay, if the debtor wanted to be in an amiable procedure, why not find solutions for him? And in this case, otherwise he won't respect the title, the enforcement. In the sense of regulation, the conditions according to which, in the event of a default judgment, a claim is deemed uncontested within the meaning of Article 3 of the Regulation of April 21st, 2004, creating a European enforceable title for uncontested claims, must be determined autonomously under this regulation. In France, there were situations before or after the title, the enforceable title was issued, when the debtor takes the initiative not to contest, and he will remain passive. So we would be in a situation in which the claim is not contested. So this is why we talked and we thought about another option in which the debtor, when the claim is certain and exigible, the debtor should pay just like that, but he has the possibility to contest the decision. Contesting a claim is in law there is a fundamental principle of contradictoriality. So the debtor has the possibility to come and contest So for us, the clearest is the procedure in which the debtor can contest the claim to pay.
Donc de contester cette...
So he can...
qu'il n'a pas eu connaissance, ou peut-être qu'il n'a pas...
Maybe he did not understand, or he didn't know about it. Or maybe there are even aspects of nullity inside the contract. In order to contest, we have to respect the principle of orality. So he has this possibility to have the history exposed, presented to him orally. Even if the claim it cannot be contested, but if we have a claim which is in principle uncontested, after the title has been issued, the debtor will have the possibility to contest, but he does not contest. We have here an intention not to contest. So the payment will be made spontaneously or through forced title. Article L 111(2) of the Civil Procedure Code states that any creditor may, under the conditions provided by law and provided with an enforceable title establishing a liquid and payable debt, pursue its forced execution on the property of the debtor under the conditions specific to each enforcement measure. The foreign decisions and those who cannot be contested are subject to the law of the European Union. And they can be executed in France or in another country. In all alternative modes of execution, we will have the possibility of having forced execution. We have different types of documents: notary documents, accords between natural persons, different types of titles. They all can lead to an executory situation. The magistrate will ask about an alternative means of resolving the issue and will offer the possibility to issue a certificate of non-payment. So the bank will have the possibility to issue this certificate. And the judicial officer will be able to go to execution based on that document. So the bank will issue the non-payment note certificate, and the judicial officer will make the judicial officer has a procedure to recover claims, which is part of the civil procedures. And for certain types of executable, enforceable titles, there is actually an alternative mode of solving the case, such as mediation, negotiation, arbitrage. So the judicial officer will impose the execution type. This procedure was complicated at the beginning. Because it depended on the will of the government and of the justice commissioners to work on in a novel way. to recover small claims. So the alternative in the alternative mode to solve to recover small claims offre une possibilité du débiteur de payer sans être exécuté. So we are in a logic in which the debtor does not contest, he agrees to pay, but he still accepts that the executor impose the enforceable title, which is the guarantee that he will pay. So you see, in order to establish this amiable alternative route, it's very difficult because the debtor have to accept this procedure. We had to fight so that we can send this document as a judicial officers and to impose an alternative means of recovering small claims. So the problem is how to send these letters. Sometimes we have registered letter. And because of the problems connected to the means of transferring of sending this letter, mediation has become obligatory. So we have to have a registered letter showing that the procedure was followed and that the debtor was informed. In forced execution, we have a lot of possible documents because we are trying to go towards the amiable solution. We have a National Council of Mediation, we have ambassador of amicable resolutions. So we don't want to finish being in a situation of incontestability. And you know that in France we have a good base from our basis is in Roman law. So the temptation is to contest everything. So we don't want to open the door of contestation, but to open the door towards alternative means of resolution. When we have an enforceable title and we begin the first execution, the enforcement, we always have a moment where we can open the door to an alternative means. To finish, in the means of execution, in the debtor can accept the payment of the claims. So he can sell amicably sell some of his goods so that he can cover the claim. This is also a possibility to find a solution for the debtor to find a solution to pay. In conclusion, I can deal like it was did before. We are confident in our civil procedures, and we would like to go towards the amicable resolution. within a system which is viable and strong. Thank you.
Thank you very much, Christine. It was a very interesting presentation. I'm sure you have a lot to tell us, but perhaps in another time because the time is short. Next, you can sit here, please. Okay. Next, we have the presentation of Jos Alten-Aak. Go ahead, you have the floor, please.
Yes, it's working. Thank you. Yeah, okay. Thank you. So we immediately start with the second slide, which is more interesting, I think. This was a saying, a properly functioning judiciary forms an important foundation for a vibrant market economy. By contrast, a poorly functioning justice system is a red flag for trade and commerce. This is not a quotation from me, but this is a quotation from a report that was recently published by the European Bank for Reconstruction and Development. They had a huge project in 13 different countries, checking whether or not those countries were able to establish online courts, which might be a topic for the future also, and a very interesting topic, because if you talk about uncontested claims, if you talk about efficiency in the enforcement proceedings, I think it's something also worth looking at, the development of online courts. Well, honestly, also, if you look at the Western Balkan countries, which I want to make a few remarks about, then I must also say that maybe it's a few bridges too far yet in that region to develop also online courts. Now, I think the first question that we have to ask ourselves is, what are uncontested claims? I took the definition as it is mentioned in the European Enforcement Order for Uncontested Claims. The reason for that I will come back later, but there are some elements in this definition that are very much of importance. The first one is verified absence of a dispute. Second one is pecuniary, monetary claims. And the third one is in a court settlement or in an authentic document. And here I have to mention already that authentic document does not mean what is at least meant by it in, for example, Netherlands or in Belgium, and I think also in France, a notarial act. Authentic document can be much broader. I will come back to that later. The other thing is we are talking about fast proceedings, and then we are talking most likely about the payment order proceedings. Well, again, here is a definition as it is in the EU regulation creating the European Order for Payment. Again, you have here some elements that are of importance. First of all, mass recovery of uncontested claims. That's important in the definition. Secondly, a simplified order for payment procedures. So it should be a simplified proceedings. Thirdly, the claimant has to provide information that is sufficient to clearly identify the claim. And sufficient is something different in comparison with normal court proceedings, I would say. Because that means it's much easier to deliver this information as long as it is sufficient. And finally, the debtor needs to have a choice whether or not to protest, to object to the claim. Well, these elements are very much of important if you talk about the payment order procedure. So that means if you talk about the payment order procedure, or I would say if you talk about any proceedings with regard to uncontested claims, what does it mean? The creditor needs to quickly obtain an enforceable title. Logic. That was the aim also of the EU regulations, we could say. Secondly, it should enable the debtor to protest, to object the claim. Thirdly, and that's quite different, the creditor and the debtor we see also back if you talk about the Western Balkan region. But another thing that we will, which differs a lot, is the scope of a payment order proceedings, or the scope of, maybe I should say, obtaining easily an enforceable title. For example, if you talk about the applicability of a payment order procedure, it might be quite different. Some countries have very much limited the payment order procedure to 2,000, 2,500, maybe 5,000 or 10,000, but that's it. Whereas in other countries, as long as it is uncontested, you can do it for any claim. And important also in that respect is different authorities are involved. Because it means as long as the claim is uncontested, that it is not necessary to have the court involved in that. I don't know if there are still judges here, but normally judges always protest if I say something like that. But not necessarily the court has to be involved in that if it is an uncontested claim. That's already quite different also. For example, you have some countries where enforcement agents, also in the Western Balkans, where enforcement agents are involved in the issuing of an enforceable document. No court involvement, only when there is an objection in the proceedings. You have other countries, for example in Croatia or in North Macedonia, where it is the notary who has a functioning as long as the claim is uncontested. So, in general, we could say that if you compare how it's organized within the European Union versus how it's organized in the Western Balkans, that there are different proceedings. Yes, most Western Balkan, I never mention them countries, I always use the term legal systems. That's a more neutral term than mentioning countries, especially if you have a regional activity where Serbia and Kosovo are both on the table. It's better to talk about systems rather than countries. So I will try to do that as much as possible also here. But you know, if I talk about systems, you know that I mean countries. So if you talk about legal systems in the Western Balkans, mostly they have two proceedings. Yes, most countries, legal systems, have the payment order proceedings. But secondly, what they also have is a special proceedings, what they call the authentic title proceedings. And the particularity there is that the authentic title procedure is not a procedure, because an authentic document, that can be an invoice, for example, can be sent directly to the enforcement agent for enforcement, without court involvement. And based on that, with a motion for enforcement, the invoice is sent to the enforcement agent, and the enforcement agent will start the enforcement. Of course, look at the elements that we just saw also in the definition of the European Union, the regulation on uncontested claims. Of course, the debtor needs to have the possibility to object such a claim. And if that is the case, yes, then of course normal court proceedings will start. But we see that this authentic document proceedings is very much of importance in the Western Balkans. I want to give one example also in the different countries. One example is in utility cases. But the problem with this is, if we link it to EU, is that it can be an enforceable title within the Western Balkan region, but it not necessarily means that it is also a cross-border enforceable title. Well, we have a number of Western Balkan systems that have now the status of candidate EU country. North Macedonia, Serbia, Albania, for example, Montenegro. But the problem will arise the moment that they will become a member, because these cases will not be enforced as easily within the European Union. You recently, I think it was 2-3 years ago, And then coming back to Croatia, where you had the notary making an enforceable title, and they thought, okay, that can be sent to another EU member state for enforcement. And the European Court of Justice was very clear on that. No way, you cannot do that. European proceedings in that respect, the regulation 805/2004 is very explicit on that. There are some exceptions of non-court decisions that can be considered enforceable title, like for example the decision of the enforcement authority in Sweden. But if it is not mentioned explicitly, you cannot enforce it. Anyway, come back to the Western Balkans. Two stages are very much of importance. The first one is obtaining the enforceable title. Easy, authentic document, send it directly to the enforcement agent. And secondly, you have the enforcement title, the enforcement itself. What is important there, and honestly what is a shortcoming if you talk about the Western Balkan region, is service of the document. Because if you want to have a well-functioning system, also with authentic documents, service of documents is vital. And you need to have a guarantee that this document, the introduction, the motion, the enforcement request to the enforcement agent, is actually also served upon the debtor. And that often causes a lot of problems. You see, with regard to the authentic document proceedings, also that there are different grounds for objection of such a claim, which is also logic, because you need to build in more protection also for the debtor in that respect. So, if you look at certain legal systems, well, for example, in Serbia, we have already mentioned that we have the order for payment procedure. We have in Serbia also the authentic document proceedings, so going directly to the enforcement agent. I mentioned already why this focus on this kind of proceedings is that if you look in those countries, and when we started working in Serbia on changing the enforcement system in 2013, 80% of all the enforcement cases were utility cases. And if you want to have a quick solution in that respect, it meant also that you should not send all those cases to court. We see that, for example, if you mention another legal system in Bosnia, the court, so the district court in Sarajevo, currently has 2 million enforcement cases, utility enforcement cases, a backlog of 2 million cases. They are unable to handle that. So that means that you need to look for alternative solutions rather than simply sending, I would not even say sending, but it is dumping of the utility companies of all those cases with the courts. And courts, now it's your problem, good luck with it. That doesn't work, of course. So that means also what you see in Serbia, what you see also in Montenegro, what you see also in Kosovo, for example, is that those two phases, obtaining an enforceable title and the enforcement itself, it's combined in one authority, the enforcement agent. I think that's very much of importance. An interesting thing, I don't know how much time I still have. Not too much, okay. Interesting thing also is, and also with a reference to what Christine was mentioning, is if we talk about easily obtaining an enforceable title, why don't we look more at, for example, mediation? And why, and then I mentioned Albania in that respect, for example. In Albania, the mediation agreement is a directly enforceable title. Again, it's not necessarily to go with the mediation agreement to the court to ask for some kind of statement of enforceability. No, directly you can enforce the mediation agreement. The same is the case, for example, if you talk about Kosovo. So, what we can learn from the systems in the Western Balkans, maybe lessons learned also for them, is that if they want to have a good functioning system, of course, for them it's very much of importance that they bring their legislation with regard to the payment order proceedings, but especially with regard to the authentic document proceedings in line with the requirements of the European Union. And then I'm referring to the two definitions that we already saw earlier. That means the debtor, for example, needs, if we look at the enforcement order for uncontested claims, it means that the debtor needs to have expressly agreed with having this document, being it an invoice, as an enforceable title. It means that it is important to know, if you do the enforcement, whether or not the debtor has ever objected. It means, have there ever been any court hearings with regard to a certain case? Or maybe the debtor expressly agreed with the authentic document as an enforceable title.
Try to finish, please.
Yes,
I'm
I'm almost done. You see, it's my last page.
Okay.
So the other thing, and that's something that we can learn from the Western Balkans into Europe, is also have the mediation agreement as a direct enforceable document. Why not? And maybe also focus more, and that was also what Christine was mentioning, focus more on out-of-court settlement, because not necessarily always it is that we need an enforceable title. We can, enforcement is a tool that we as enforcement agents can use to satisfy parties. But it's not absolutely necessary to do attachments, for example. Procedural simplifications, we can also learn in that respect, I think, from the Western Balkans. And there should be clear rules on objection, clear rules with regard to delays, the need to provide explanations, for example, by the debtor, and certain time limits. And in that case, we can look also to the Western Balkans and maybe have something also implemented in the systems within the European Union. Thank you.
Thank you very much. Yes. I'm sure we have to find a lot of solutions for your problem, for the problems that you mentioned. Now I would like to give the floor to Johan Les, if you please. Thank you very much.
Je voudrais commencer pour vous dire que dans les dernières années, je suis très préoccupé sur la durée des procédures judiciaires. C'est un thème qu'on discute dans tout le monde. Je suis aussi préoccupé de le durée raisonnable, un syntaxe très exact et très harmonieux, à mon avis.
I promise you that we won't have problems with reasonable timelines, because I always know when I begin. I know that I never know when I'm going to finish. I would like to add something to congratulate Adrian Stoica, our Dean of Faculty of Law and Administrative Sciences of Constanța, for the excellent organization of this conference. I'm very surprised to see how he has managed to bring here half of the scientific board of the International Union of Judicial Officers. I can see here today Professor Emerson, Professor Aida Gölmer de Carlucci, who comes from Argentina, Mr. Mendoza, I also see here Professor Nathalie Frissereau from France, and I had forgotten to say that she's also a member of the French Institute and of the Honorable Legion of France. This is a real honor. So it's really honorable to have here all these personalities that I can see in the room. I can also see the former president of the International Union of Judicial Officers, Mr. Schmidt, who is still with us. It's a great pleasure to see you. So now I would like to make a little introduction about the crisis of justice.
Enforcement of real estate is one of the enforcement forms that is indirect and which has the toughest effect in relationship with the debtor's property that can lead to losing it and losing the right over a non-movable good.
Ils sont nos parents en ce qui concerne les droits. Et bien, nous ne devons oublier jamais cette chose. Et je voudrais dire que dans les droits, il y a le professeur.
Roger Perron has talked in his book about the crisis of justice in France. Half a century has gone by since he talked about the crisis. So, look, not only in France, but also in Romania, Italy, Spain, there are tribunals, courts, which are paralyzed in France. There are also strikes, a terrible crisis in Italy. There are also lawyers who took to the road, to the streets, to ask for the work of judges to be rationalized. I don't have the time to make a history of Romanian justice. I'm going to limit myself to saying only this. We have modified, changed in a very important way the Civil Procedure Code of 1900. This is a great reform. A lawyer made a commentary, an observation, on the new Civil Procedure Code. He said, with these reforms, we will get to a better type of justice, that we hope that the judges will enter in the room with 25 to 30 cases per meeting. Nowadays, a judge who is member of the upper council of the magistrature was saying that judge in Bucharest enters the room with more than 100 files. Here, that's the progress. This is justice. There are several causes. Unfortunately, we rarely have the number of cases we have makes the system lag. It appears to me that nobody wants to really make a reform, to make radical changes. So if someone has the courage of asking how the justice was 30 years ago, my response is that it was nothing like justice today. This is my way of seeing things. Probably I'm wrong. Without a good reform, we will never be able to enact justice. I'm sure that we are going to talk about this in. So I'm sure we will be talking about the crisis of justice in half century.
Imediat.
Allow me to say a few ideas on the problem, the issue of forced execution, enforcement. The Constitutional Court treats in a very interesting, not necessarily good manner, forced execution. There was a time when we did not need the approval of a judge, even if in the room there was a judge in the Supreme Court of Justice. So you could ask me why I'm talking about this today. It's because the Constitutional Court gave two decisions in 2009-2015 saying that the approval of forced execution by the judges was not constitutional. From my point of view, this is completely wrong. This is a grave mistake. But there are two decisions. I'm talking about these problems today because there are reforms in France, in Italy, because they adopted some reforms For example, in Italy, the enforcement formula has been abolished, which is very interesting. It's so the approval by a judge of the execution is not necessary. In many countries, this approval is not necessary. This is why I'm talking about this, and I hope that this change of, in this change of opinion, in the opinion of the Constitutional Court. I've already spoken about how the Constitutional Court sees some of the law issues. And some of situations which are not constitutional in Romania are constitutional in France. I have an example on the role of the prosecutor. In the application of forced execution. In France, there is a provision in the Civil Procedure Code that says that prosecutors must be involved in order for the forced execution to be applied. And our Constitutional Court says that this is not normal, that prosecutors don't have the necessary force to intervene. On the other hand, the Constitutional Court was saying that this legal solution gives us the impression that the prosecutor occupe la chaise de la justice, mais qui sait pas that the prosecutor occupies the chair of a judge, which is not the case. Another example, a year or two ago, we had a case Serrano in Romania. A little girl who was adopted who was adopted by a family from Professor Emerson's country. I hope that this girl is okay in America. In Miami, this little girl refused to go with the adoptive family. There was a scandal in Romania. The People's Advocate intervened with all his force at the limit of between criminal and civil law. But today this case is closed. Nobody is talking about it anyway.
And give the floor to Dean Adrian Stoica. Thank you very much for your presentation.
Thank you very much.
Thank you very much, Mr. Cardoso. With your permission, I will respect the language who Professor Voicu read it, his article, and I will present that article in the French language. So, Mademoiselles, Messieurs, chers collègues et amis, chers étudiants et masterants, je suis très honoré de vous présenter en quintessence et synthèse dans un temps rigoureux.
I will try to, ladies and gentlemen, I will try to present the article of Professor Marin Voicu in 10 minutes. The title is Enforcement in the European Court of Human Rights Case Law and the Effectiveness of its Decisions in the Council of Europe Member States. The full text of this paper will be available with the secretariat of this conference. There is a structure on chapters. The first chapter regards the enforcement procedures in the jurisprudence of the European Court of Human Rights. The second, the authority and efficiency of the European Court of Human Rights decisions in the Council of Europe member states. Here he has different sections, such as general principles issued by the European Court of Human Rights. The second section, applying the principles in law cases against Romania. And the third section, conclusion regarding internal mechanisms and the progress of Romania. The third chapter, the control of the European Court of Human Rights of enforcing its decisions. This also has a few sections. The first one, the normative and jurisprudential framework of the control. The second one, the report of the Parliamentary Assembly of the Council of Europe 2017. The conclusions, of course. And the third section, the conclusions of the last report, 2022 report of the Committee of Ministers and the last section, the European Court of Human Rights faced the opposition of contracting states. For 25 years, the problems concerning the first execution at the European Court of Human Rights So we are putting into discussion the progress made by the decisions of the Court of Human Rights. The analysis considers 10 member states, Italy, Romania, Moldova, 10 states which have a very great number of enforceable titles. These states have 80% of the cases of forced execution. And this requires the attention of special attention because most of them are not executed. In the report of 2022, there is a change in attitude regarding the execution of enforceable titles. The execution of the enforceable titles is the guarantee of the protection of human rights. This has become a very important problem for the future of human rights in the European Union. It is very important to execute and to enforce all titles in a timely manner. until now, we haven't had member states who refused to execute, to enforce titles, but there is a lack of willingness of the states to execute rapidly all the enforcements of the courts. So it is essential to make sure that all enforcements are applied in due time, because this is the guarantee of human rights. Articles of the convention require a better cooperation between institutions in order to ensure the application of human rights. I also have congratulations from Professor Marin Voicu to Professor Ferrand, and all his. I'm sending his consideration to all the other participants. Professor Frisero and Professor Ferrand are congratulated for being two pillars in the regard of the direction of judicial officers and the development of their activity. Thank you also for having elaborated the world code of judicial officers and the digital world code of judicial officers. The former regards the importance and the inclusion of the digital in the activity of judicial officers. Once again, congratulations. Thank you, everyone.
Adrian, I'm sure you will give our greetings and thanks to Mr. Marin Voicu. Now I would like to give the floor to Bogdan Dumitraș. If you can please give your presentation in 10 minutes, it would be very nice.
Yes, thank you very much. Mesdames et messieurs, distingués spécialistes en droit en général et en droit de la procédure civile, et notamment de la procédure d'exécution forcée, ma petite intervention, je promets de m'encadrer en 10 minutes.
Professor Voicu's presentation had 3 chapters. Mine it's the same. I have 3 chapters. First of all, congratulations. The second, excuses. And the third one,
brief considerations on the non-public nature of public tenders in the
regarding
procedure. The Code of Civil Procedure guarantees the public nature of the auction by regulating, as a mandatory provision, ways of informing the public about the existence of the public auction period and the basic elements of the auction. The scope of the discussion, public auction of immovable property, guaranteeing public access to the place of the auction, but in guaranteeing access to the place of the auction to the person allowed by law to participate in the public auction period. Ways of making public auction known depending on the categories of persons concerned and the purpose of informing about the auction. So, real estate domain. Informing the public to inform the debtor, third-party guarantor owner of the auctioned property, and informing interested third parties. What's the purpose? To obtain the highest possible auction price. Then to inform the debtor or the third-party guarantor, owner of the auctioned property. The purpose is to obtain the highest possible auction price. In so far as it can attract interested third parties to participate in the auction that is going to take place. Knowing the date of the auction, the debtor has the possibility to evaluate the procedural means to stop the procedure. Appeal against auction, application for suspension of enforcement, deposit with special assignment of the entire amount due in order to stop the pursuit of the property. The price has to be sufficient enough to cover all the créances. Possibly leave money left for the debtor. Informing interested third parties, person holding lines on the property put up for sale. Purpose: to know the progress of the procedure in order to decide to become involved in the procedure, intervention in the enforcement. The purpose of advertising is to obtain the best possible price for the property. The higher the price, the higher the coverage or claims. If the coverage exceeds 100%, a difference is created between the auction price and the sum of all claims that can be remitted to the debtor who owns the property. Advertising issue provided or enforced by law to attract bidders. Content of the sale publication, elements relevant to the publicity of the auction, identification of the immovable property offered for sale, specification of the date, time and place of the public auction, the conditions for registration for the auction, the deposit of 10% of the starting price, and the submission of the purchase offer, the condition governing the award of the contract, which shall consist mainly of a minimum price and a time limit for payment of the difference in price. Ways of publicizing the sale publication. Display of the full version of the publication at the seat of the enforcement body, at the seat of the enforcement court, at the location of the property sought, at the seat of the town hall in whose district the property is located, and the place of the auction. In practice, the place of the property auction is often the seat of the enforcement body. The publication of an excerpt containing the relevant information for advertising in a newspaper, local newspaper for properties with a value of up to 250,000 lei, approximately 50,000 euros, or a national newspaper. Publication of the publication in electronic register of advertising the sale of goods subject to enforcement, kept by the National Union of Enforcement Agents in Romania. Publication of the publication in newspapers, magazines, and other existing publications intended for the sale of the real estate for the type put up for auction, including on websites open for this purpose. The advertising provided for previous points 1 to 3 is compulsory. The advertising provided for in point 3 is provided for another penalty of utility. The advertising referred to in point 4 is optional. The legislator is not entirely confident that the requirements laid down for the advertising of public property auction guarantee the best possible price. The symptoms of mistrust, the condition of a plurality of bidders for the award of the property for a price lower than the starting price of the auction, a condition imposed both for an award at the second term. The starting price of the second term is 75% of the starting price at the first term, in turn equal to the value established by the expert appointed by the bailiff. It should be noted that the requirement that there must be more than one bidder is in principle unjustified, not only because okay. Thank you for your attention.
Well, I just heard that we have only 13 minutes to lunch, so I think I even not going to read my conclusions because we don't have the time. I'm very sorry, but we have no more time. And so if anyone has some questions, you can do it after lunch, okay? Thank you very much, and I'm sorry.
Greetings, everyone. It's wonderful to have you here. Are you going to stay here with me or not? No? Okay, fine. Our schedule is quite tight, so let me introduce myself. My name is Anthony Murphy. I'm assistant professor at the law school of the Ovidius University of Constanța. And I have the honor of chairing panel 2 today. After the stellar lineup of the earlier panel, I am proud to introduce 5 equally stellar speakers, authors of 5 papers dedicated to the topic of enforcement and enforceability in Romania. Each presentation shall take approximately 10 minutes. The speakers will answer your questions in the final part of the panel during the so-called panel discussion. I will be taking your questions once the final speaker has finished presenting. Now, let me first introduce the first paper. It belongs to Ioana Varga, attorney and senior lecturer of civil procedure at the Babeș-Bolyai University of Cluj-Napoca. Joining her today and speaking on her behalf as well is Gheorghe Buta, first-class researcher at the Andrei Rădulescu Institute of Legal Sciences at the Romanian Academy, former judge and currently an attorney. They will discuss the role of the decisions of the High Court of Cassation and Justice in unifying the practice in the field of enforcement procedures in Romania. Professor Buta, you have the floor.
Bonjour, mesdames et messieurs. Tout d'abord, je veux vous communiquer le regret de ma collègue Ioana Varga, qui n'a pas pu venir. Elle est à Gdańsk, en Pologne, à une réunion des avocats européens, et c'est pour ça qu'elle n'est pas là maintenant. Et je veux emprunter quelque chose de M. Dumitrache, c'est-à-dire j'ai emprunté 2 chapitres de sa présentation, c'est-à-dire le premier chapitre, félicitations. Et je m'arrête ici parce que si j'ajoute quelque chose, je ne fais que diminuer le mérite de ceux qui ont organisé cette réunion. Deuxième chapitre, excuses. Tout d'abord, je vous prie de m'excuser, de me pardonner si, parfois, j'espère que seulement parfois, je serai incohérent, et ça, à cause du temps qu'on a pour notre présentation. Et aussi des excuses parce que probablement, je ferai des fourcullitions. Pour nos collègues français, ça ne dit rien, mais mes collègues roumains, ils comprennent très bien qu'est-ce que ça veut dire. Ça vient d'une comédie classique roumaine. Et c'est parce que fourchette, en roumain, c'est furculiță. Et on disait que c'est très facile pour les Roumains de parler le français. Il faut ajouter au mot roumain la terminaison sion, on peut nasaliser et on parle le français. C'est une très courte, très brève explication. Et maintenant, le chapitre proprement dit, enfin la présentation. Mais comme je viens de dire, parce que le temps est tellement court, je veux vous préciser que l'article préparé a presque 30 pages, et ce n'est pas fini. Et vous aurez l'occasion de le lire dans le livre qui va apparaître. Et la thème, on a considéré qu'elle est intéressante pour... à cause du temps, je vais passer.
This paper examines the role of precedent in a codified judicial system and highlights distinctions from common law systems. The significance of High Court of Cassation and Justice in ensuring uniform interpretation and application of laws is highlighted, although these decisions lack the creative nature of law, but are rather interpretative in character. The procedure of forced execution is presented in an area requiring uniform interpretations, and the author intends to analyze relevant judgments to illustrate the essential aspects of this subject. This paper also debates significant interpretations regarding the competence of enforcement authorities and courts. Through decision number 20/2021, the High Court of Cassation and Justice established that the competent court to adjudicate on an enforcement appeal is the court that granted the forced execution with limited exceptions. The arguments in this judgment have clarified important aspects concerning the procedure and the competence of the enforcement court, emphasizing the gracious nature of the forced execution authorization procedure. Further on, the author observes that the interpretative decision has exceeded the boundaries of a mere response to questions of interpretations, providing a detailed and reasoned analysis of the grounds for the conclusion. Emphasis is placed on the necessity of providing reasons for interpretative judgments and the importance of determining the nature of the procedure and the applicable rules for establishing the competence of the adjudicating court. Furthermore, the paper mentions the subsequent intervention of the legislator, which amended legal provisions, including those providing in the decision of the High Court of Cassation and Justice, highlighting the complexity of this field. The author argues that uniform interpretative decisions were necessary to resolve jurisdictional conflicts and that standardizing judicial practice is essential to ensure consistency in the interpretation of competence norms. This paper also analyzes decision number 20 of September 27, 2021, issued by the High Court of Cassation and Justice, in which the competence of the enforcement court, regulated by the Article 651, paragraph 1 of the Code of Civil Procedure, was discussed. The conclusion of this decision was that this competence is exclusive, both in terms of subject matter and territorial jurisdiction, with exceptions only in cases where the debtor and the creditor do not have their domicile or registered office in the country. The author emphasizes that the moment of authorizing forced execution is essential for determining the enforcement court, and this competence is granted to the creditor in this phase of the civil procedure. The decision of the High Court establishes that the procedure for authorizing forced execution is subject to the jurisdictional rules of non-contentious proceedings, with reference to the provisions of the Civil Procedure Code. Furthermore, it is emphasized that the Article 651, paragraph 1, with Article 109 of the same code is not possible, as the former regulates exclusive territorial competence, while the latter refers to alternative territorial competence. This is a rigorous and strict interpretation of the law, making it impossible to apply the common rules of alternative territorial competence in this context. The paper also mentions the importance of decision number 17 per 2020 of the High Court of Cassation and Justice, which clarified the material competence of the insolvency judge in cases involving appeals related to forced execution within the insolvency procedure. In conclusion, the paper highlights the importance of interpretative and clarifying decisions in the context of forced execution and enforcement titles, providing a detailed analysis of these aspects. It also addresses issues related to the conclusion of distance contracts for final services and their enforcement process. The paper also focuses on aspects related to the procedure of forced execution, including the rules for challenging court decisions in enforcement matters. It examines how court decisions have contributed to the unification of judicial practice, especially regarding the statute of limitations for enforcing a debt secured by a mortgage. The paper also addresses the application over time of provisions related to forced execution in the legislative context of Romania. The author highlights that there are legal provisions regulating the statute of limitations for seeking forced execution, distinct from the statute of limitations for bringing an action. And this is important because these statutes have different objects concerning the possibility of seeking forced execution of an enforcement title, which involves obligations to give, do, or refrain from doing in accordance with the nature of the obligation. Furthermore, the paper discusses the application of provisions of the Civil Procedure Code regarding the statute of limitation for seeking forced execution, emphasizing the need for this to be correlated with the provisions of the Civil Code. It is stressed that in the case of real rights, there is no clear distinction between principal and accessory real rights, and the right of mortgage, although not expressly mentioned, can be included in this category. The argument is then made that the interpretation of the legal text in the Civil Procedure Code suggests a statute of limitations of 10 years for the right to seek forced execution for all titles related to real rights, whether they are principal or not. There is also an observation of a correlation between the mortgage action right and the right to seek forced execution, supporting the 10-year statute of limitations for these rights. In conclusion, the paper emphasizes the importance of correctly interpreting and applying legal provisions regarding forced execution, highlighting the evolution of legislation and the need for clarification to ensure consistency in judicial practice.
Thank you, Professor Buta. The second paper will be presented by Evelina Oprina, Judge, Professor of Civil Procedure at the Dimitrie Cantemir Christian University of Bucharest and former member of the Superior Council of the Magistracy in Romania. She will discuss the provisional enforcement judgments between benefit, risk, and challenge. You may proceed.
Thank you very much for the invitation to this important event dedicated of enforcement, and for the presentation. Thank you, Anthony. I will try to resume my presentation, to which is important, essential, in order to fit the time provided. The topic I choose to present today is of a particular practical importance and raises a number of issues. The plans of my analysis are benefits, risk, and challenge of regulation. Not necessarily separately, but through each other. For the beginning, I think brief overview into the analyzed is required. So, the temporary execution is an exception to the rule according to which, in order for judgment to be enforced, it must be final. A conclusion that follows from the provisions of Article 632 of Civil Procedure Code. The regulation of temporary execution can be found in the provisions of Article 448 and 449 Civil Procedure Code, from which it follows that temporary execution has two forms: legal temporary execution and judicial temporary execution. The first plan of analyze consists of benefits of regulation. There are two benefits. First of all, it should be mentioned that the reason for this regulation results from the idea of urgency. Urgency that characterizes the requests refer to Article 448 and 449 Civil Procedure Code, and which demands fast execution, either to prevent damages or in consideration of creditors' personal situations, or following the recognition by the debtor made during the trial. The advantage is that judgments are recognized as enforceable from the moment of their pronouncement by the first court. The only requirement being that the claims that have attached such character are either specifically provided for by the legislator or their enforceability is recognized by the court. A second benefit of judgments with this provisional enforcement consists in the fact that, according to Article 706 Civil Procedure Code, the prescription period begins to run from the date they become final, not exposing the creditor to a risk resulting from the benefit granted itself. The second plan, the risk of regulation. The provisional enforcement of court decisions is done at the risk of creditor, which means that if the decision, judgment is cancelled, modified, or abolished after the transition to forced execution, the creditor will see himself exposed the risk to the return of execution. So he will have to return to the debtor everything that was executed on the basis of the provisional title, inclusive the execution expenses for which the creditor will be held responsible, of course. The third plan consists of challenges of regulation. Although the text 448 Civil Procedure Code does not seem to regulate a limit, but on the contrary, an extension of the cases in which judgment can be enforced, I will analyze the norm by referring to the limit that establishes it within its regulatory sphere. So, the limit that derives from the regulation of Article 448 Civil Procedure Code is as follows. The enforceability to the first instance judgment exists only when the obligation to pay the amount due with the titles mentioned in the text is formulated in the main way. Although the text of the law does not distinguish in terms of the procedural path chosen by the party to exercise its right, in reality, such a distinction must be made in the context of Article 448. And in order not to be accused of introducing distinctions that the legislator did not have in mind, I'm going to refer to the arguments consists in form, substance, letter of the norm, and reason of the legislator. First of all, it should be noted that from the point of view of the field of application, the text 448 refers to the first instance judgment that have as their object the claim listed in the text. Consequently, the claims must be brought to trial by the main way, as they are the ones that generated the litigation. Accessory claims are those whose invocation derives from the main claim. They are related to the main claim, and their resolution depends on the solution given to the main claim. The accessory claim being in a procedural subordination to the main claim, it cannot play the determining role in configuring the procedural framework. It can be concluded that, relevant from the perspective of enforceability, is the solution given to the main request. Moreover, it can be accepted, for example, as that the main obligation, as example, the dissolution of the marriage, should not benefit from the attribute of executoriality. Instead, the accessory head of claim of the divorce should enjoy such a character. So it can be accepted, this solution.
I'm sorry, you only have 2 minutes left.
Okay. On the other hand, from the perspective of the reasoning of the rule inscribed in Article 448, it is noted that the regulation is justified only in consideration of the urgency of realizing of certain rights. I will invoke related this opinion, the decision number 19 from 1965 of the plenum of the Supreme Court. In conclusion, executoriality regulated by the Article 448 Civil Procedure Code must be related exclusively to the claim that generated the litigation, and in no way to an accessory claim. The urgency claim by the text is not found in the reason of a claim whose achievement is only accessory, dependent therefore on the main claim, and which does not know by itself the degree of urgency assumed by the legislator. This was my brief presentation, and thank you very much.
Thank you very much, Professor Oprina. Now it is my honor to invite my colleague, Madalina Botina, lawyer and associate professor of family law and private international law at our law school. She will discuss the effects of foreign judgments through the lens of French and Romanian case law. I think you also have a PowerPoint, right? All right. So, you know the rules, 10 minutes.
My presentation is in French. It's a great honor to be here with the professors, researchers from other countries. It's also a great honor to be here. The topic of my presentation is the effects of foreign judgments in French and Romanian case law. In principle, for a foreign court decision to produce its effects, it must be considered regular by the required legal order, that is, the legal order in which the question of these effects is raised. We generally distinguish in a court decision its substantial effect and its attributes. The substantial effect of a decision lies in its normative effect, the impact of this decision on the legal order, pronouncing a divorce, transferring ownership of property, extinguishing a debt, cancelling a contract. Beyond this normative effect and to guarantee its effectiveness, court decisions also have two attributes, res judicata and enforceability. The authority of res judicata prevents the decided question from being posed again to a judge. It is a matter of non-receipt. It thus results that the essential of the effects of a foreign court decision involves its acknowledgement. From this perspective, as with the rules of jurisdiction, EU law has gradually taken first place in international trade. There are three conditions apparent that have to be fulfilled as far as the regularity conditions are concerned. If we leave aside the specific rules regarding the protection of weak parties, Article 45 of the regulation provides only for three conditions, which are moreover not presented as conditions of acknowledgement, but as exceptional cases of refusal of acknowledgement. Acknowledgement is refused if it is manifestly contrary to the public policy of the requested state. In the case of a decision rendered by default, if the document initiating the proceedings has not been regularly delivered, if the decision is irreconcilable with another decision already having the authority of res judicata in the requested state. Contrary to the EU law, common French case law does not in principle and in an absolute manner give automatic effectiveness to foreign decisions. As far as the automatic acknowledgement is concerned, the Brussels first bis regulation also continues the simplifying work initiated by the Brussels Convention of 1968. Under the terms of Article 36, decisions rendered in civil and commercial matters in a state member are automatically recognized in other member states. Until recently, and still under the rule of Brussels First Regulation number 44 per 2001 of 22nd December 2000, decisions were automatically acknowledged by all EU states and however they were not enforceable by right. The enforcement involved in a procedure known as exequatur, which was certainly very largely simplified but which existed anyway. The idea remained that only the judges of the requested state could demand and order all bailiffs to enforce the respective decision, and the prosecutor general and the prosecutors of the Republic from the judicial courts to support this situation when requested legally. There was a seemingly impregnable bastion of sovereignty. The new version of the regulation, Brussels First bis number 1215 per 2012 of the 12th December 2012, has put an end to this concept. From that moment on, by application of Article 39 of the above mentioned regulation, the decisions rendered by a member state which are enforceable in the respective state are automatically enforceable in all member states. As far as the evolution of the French case law is concerned, in contrast, the French jurisprudential law appears less liberal. This is explained quite easily. The rules arising from European Union law are intended to govern the traffic within the European Union between countries which maintain a certain law community. Currently, the positive law therefore acknowledges as regular foreign decisions those which satisfy three conditions. They must comply with international public order, they must be obtained without fraud, they must have been rendered by a judge having indirect jurisdiction within the meaning of the Simicht ruling. On the other hand, the French case law does not recognize any automatic enforcement. Even in matters of personal status, foreign court decisions, apart from EU law, are never legally enforceable.
à exécution, généraux et
The question remains whether a person can bring an action before the judge seeking to establish the irregularity of a foreign decision, even though no enforcement has yet been requested. The question is whether the plaintiff then has a born and present interest in taking action, a condition for any legal action. For this, see the Code of Civil Procedure, Article 31. Whether the foreign decision in question has an automatic effect is hardly debatable, and the case law admits it. Otherwise, we can seriously doubt it. And this subject is open to debate after everybody finishes his or her presentation. Thank you.
Thank you very much. Coming up next, Babeș-Bolyai University of Cluj-Napoca, Roxana Dan, who I would like to congratulate for her successful defense of her thesis, I think a week or so ago. Congrats. She will be discussing the force enforcement in kind. In other words, the enforcement by substitution at a debtor's expense. You don't have a PowerPoint? No.
Thank you for the nice and kind introduction. I will speak in French. That was all information.
Hello, thank you for your invitation, and I want to express my gratitude for being here in the company of so many renowned legal professionals. Enforcement in kind in the Romanian space covers a set of somewhat complex measures, all intended to give satisfaction to the creditor by various means, such as effective positive performance, remedying defections, the return to compliance, the cessation of the illicit act, etc., without paying too much importance from an objective perspective to the person or entity that carries them out. The enforcement at the debtor's expense assumes that the person fulfilling the obligation is nor the debtor per se, but the creditor himself or third parties chosen by the latter, the debtor ultimately being obliged to pay a sum of money. In this context, part of the doctrine affirms that the enforcement carried out by the creditor or by third parties at the debtor's expense is part of the enforcement in kind, basing this argument on the fact that the beneficiary creditor receives exactly the service he had contracted for. On the other hand, other researchers in the field argue that they are rather integrated into the concept of enforcement by equivalent, the debtor being obliged, in short, to pay for damages. At the level of legislation and of our judicial practice, if we compare these types of enforcement to the institution of damages and compensation, in our opinion, these forms of enforcement are certainly part of forced execution in kind from the perspective of the dissatisfied creditor or by relating to the objective construction of the legal relationship. From a procedural perspective, the inclusion of this form of enforcement in one or the other category entails a whole series of notable consequences which change the incident paradigm and which can entail certain consequences, including on the rules of the enforceable law. Practically, one could imagine several situations in which the creditor himself fulfills the obligation assumed by the debtor, or in which he has it carried out through third parties, the actual manner being different depending on the moment when the creditor decides to perform the obligation unfulfilled by his debtor. However, for reasons relating to the time allocated to the discussion, I will focus on the situation where, between the parties, there has already been a dispute and the creditor is in possession of an enforceable title to fulfill a performance obligation. The distinction between the two hypotheses is dictated by the moment when the authorization of the creditor takes place, respectively, within the framework of the dispute or directly in the enforcement phase. The first possible situation, the authorization of the creditor by the enforceable title itself. This institution is underlined by Article 1528 of the Civil Code, according to which, in the event of non-fulfillment of a performance obligation, the creditor may, at the debtor's expense, perform or have the obligation performed. From a processual and enforcement perspective, the specification of Article 903 of the Code of Civil Procedure is these specifications are incidental. A first hypothesis is connected to the situation where the creditor of the obligation asks the tribunal to oblige his debtor to perform the obligation in kind, and at the same time he requests authorization from the authority to perform the obligation at the debtor's expense, as in the following example identified in the judicial practice. The buyer of real estate, an apartment, has taken legal action against the seller, the builder, to remedy the deficiencies in the roof of the purchased building. Otherwise, the buyer is authorized to carry out the works himself at the debtor's expense. But the court decision rendered on 6th July 2017, we refer to the dates because they are relevant for the economy of the case, after the administration of the evidence, the court obliged the debtor to repair the roof structure of the building located in Dej, to carry out all necessary repairs in the apartment. Otherwise, it authorizes the plaintiff to carry out these repairs at the defendant's expense. The deadline given was 13th August 2017.
La structure du toit de l'immeuble si incluse, d'effectuer toutes les réparations nécessaires dans ces appartements. Au cas contraire, autorise la demandeuse d'effectuer ces réparations auprès de la débiteur jusqu'à 30 août 2017.
It is certain that in such a situation, the creditor cannot proceed with the performance of the work before the expiration of the deadline established by the judge in the decision. But it is appreciated that once the deadline has expired, the creditor may proceed to fulfill the obligations at the expense of the debtor without it being necessary for the latter to be again served with formal notice or notified regarding this aspect. What does at the debtor's expense mean? According to Article 903 of the Code of Civil Procedure, a text which governs the hypothesis of enforcement in kind of performance or non-performance obligations according to an enforceable title, if by the enforceable title the creditor has been authorized that he himself performs or causes the obligation to be carried out at the expense of the debtor, or as the case may be, that he withdraws or removes what the debtor has placed in violation of the non-performance obligation, it is no longer necessary to obtain a new enforceable title which establishes the damages owned by the debtor, or as the case may be, the counter value of the work necessary to restore the situation previous to the violation of the non-performance obligation. In these later cases, the respective sums are established by the bailiff following a specialist expertise or in accordance with other supporting documents according to the provisions of Article 628. What is the method of establishing the monetary equivalent of the unfulfilled obligation? Going further, suppose that the debtor in the case dealt with by the court does not fulfill his obligation and the creditor proceeds to the performance of the obligation by a third party, most likely by appealing to a specialized company, and manage to finalize the work mentioned in the court decision for a certain sum of money. In relation to this situation, we appreciate that the supporting documents to which the Article 903 of the Code of Civil Procedure refers to could be a contract for the provision of services, work estimates, invoices, receipts, or any other entries which prove the payment of the respective sum for the fulfillment of the obligations mentioned in the enforceable title, and according to which the creditor can demand from his debtor the payment of their equivalent value. In the event of voluntary non-performance of the obligation to pay the equivalent of the sum, the creditor can initiate enforcement by calling on a bailiff to finalize the obligation, this time being a pecuniary obligation, which can be carried out more easily. However, in the situation where the amount of money is not determined using records from third parties, the bailiff will establish the amount due through specialized expertise. In our opinion, such an expertise should be ordered by summons from a bailiff where there are no supporting documents for the sum required, respectively where the creditor himself does not know or cannot prove the sum of money that should be requested from the debtor. For example, the enforceable title provides for the obligation of the debtor to dig a ditch of 10 meters in length, which the creditor, upon the expiration of the deadline set by the court, digs himself without calling on specialized services. It is natural that in such a situation, the debtor who faces enforcement for a sum of money is authorized to contest the extent of the debt by contesting the enforcement, a context in which the enforcement body will proceed to the administration of a complex evidentiary test, including a specialized technical expertise to determine the amount due in this respect. A possible dilemma that appears in the process of quantifying the service performed at the debtor's expense consists of the debtor's obligation to find the lowest market price. We wonder in this context if the reduction or refusal of the granting of the sum already paid by the creditor could be arranged with the motivation that he had the obligation to find the cheapest form of obligation performance. We do not think that the one who benefits from a right, the creditor in this case, can be obliged to bear part of the costs due to the performance based on the grounds that the debtor would have performed it otherwise and perhaps cheaper, especially since he had the opportunity to perform it and refused. However, the limitation observed in the analysis of these sums is due to the clear disproportion between the sum demanded and the average market price, or to a possible abuse of rights on the part of the creditor, who would have incurred high costs. For example, in the above-mentioned case, he could have repaired the roof with a sheet of gold, or he could have carried out work inside the apartment above the agreed standard or above the previous standard of the building. In our opinion, in this procedure, the judge should grant the creditor the sums of money that he had paid in order to fulfill his obligation, the only limitation which could determine a partial grant being the abuse of rights or the existence of a clear disproportion between the average market price and the sums claimed, this constituting another form of abuse. The second hypothesis regards the authorization of the creditor in the performance phase. This second hypothesis is where the creditor has an enforceable title to fulfill the performance obligation, but he has not requested through the initial request the authorization to carry it out in the event of default by the debtor. This is underlined in Article 904 of the Code of Civil Procedure. In this situation, the creditor must initiate enforcement according to the standards of common law, while the bailiff must request authorization from the enforcement body for the obligation to act specified in the enforceable title. If, after receipt of the summons, the debtor persists in not performing the service, the creditor must send a request to the enforcement body to obtain the authorization to perform the mentioned obligation personally or by third parties in the enforceable title. The judgment procedure is characterized by adversatility. In such a case, the authority is obliged to cite the debtor, who obviously will be able to formulate his defense linked to a possible voluntary performance or to other aspects relating to the quality of the enforceable title, such as including prescription of the right to seek enforcement. After the administration of the probationary period, in the event that the debtor's defense proves to be unfounded, the authority will have, by an enforceable order, to authorize the creditor to perform the obligation by himself or by third parties at the debtor's expense. At the same time, the enforcement process continues in the manner previously described for the payment of the sum of money, and the discussions carried out above still remain valid. To conclude, we believe that the two situations, though similar in purpose, imply on the part of legal professionals different approaches, always capable of resolving a legal conflict between the parties as quickly as possible.
A female colleagues panel. Okay, I will introduce another colleague, Cristina Ramona Duță, lecturer of civil law, former president of the Constanța Tribunal. She will discuss the enforceability of lease agreements. I think she also has a PowerPoint. Flavia isn't here.
Yes, I do. Thank you. I intended to take the presentation in English. However, lorsque je notais que parmi nous, il y a plusieurs parleurs en français, je veux présenter en français. Oh. Je veux parler de bail en tant que titre exécutoire. Merci. Anthony. Le nouveau Code civil
The lease is an enforceable
The new
title.
civil codes regulates the character of the lease contract.
The paper
as an
explores the legal concept of an enforceable title in the context of civil procedure, specifically in accordance with the provisions outlined in the Code of Civil Procedure and the Civil Code. Article 532 of the Code of Civil Procedure establishes that enforcement can only be carried out on the basis of an enforceable title, which includes judgments, provisional enforcement judgments, final judgments, and other documents designated by law. A substantial portion of the paper delves into the conditional enforceability of tenancy contracts, primarily focusing on rent payments. According to Article 1798 of the Civil Code, tenancy contracts concluded in authentic or privately signed form and registered with the tax authorities. One interpretation suggests that the article imposes a general and additional condition for all privately signed documents that the law designates as enforceable. According to this view, a privately signed document must not only be declared enforceable by law, but must also be registered in a public register to gain enforceability. The term public register is narrowly defined to encompass only those registers accessible to the public, such as the land register or the commercial register. The paper also discusses the legislative documents related to enforceable titles, notably the amendments introduced by law number 297 per 2018 and the law number 196 per 2020. Moreover, the paper explores the balance between the creditor rights and the procedural formalities, emphasizing that enforceable tenancy agreements must still undergo certain procedural steps before actual enforcement. The author analyzed the issue regarding the enforceability date of tenancy contracts and unpaid rent, offering two contrasting perspectives. One view points that enforceability attaches to the contract once it is registered with tax authorities, while the other contends that only rents calculated after registration are enforceable. Further on, the legal status of rents established through additional deeds and the enforceability of late payment penalties and utility charges within the framework of tenancy contracts. Additionally, the paper discusses the enforceability of tenancy contracts for the return of property. According to the Article 1809 of the Civil Code, fixed-term tenancy contracts terminate automatically at the agreed-upon term's end without the need for prior notice. The enforceable title status for the return of the lease property applies when the contract is executed in the prescribed form or when registered with the tax authority. It is crucial to emphasize that the special procedure outlined in the Code of Civil Procedure does not affect other rights and claims related to the lease, such as rent payment, damages, or other contractual or legal rights. This procedure is optional for those who may choose between this special process and the standard procedure. Furthermore, jurisdiction for claims under this title rests with a court situated where the unlawfully occupied, rented, or leased property is located. The paper explores the termination of lease agreements with a particular focus on the enforceability of eviction based on the tenant's non-performance of essential obligations. It highlights that with certain types of tenancy agreements can serve as enforceable titles for eviction, there are specific circumstances in which they do not qualify for this status. In conclusion, the paper emphasizes that the designation of a lease as an enforceable title is not applicable in all situations where the lessor seeks rent payment or the return of the property. It underscores the limited scope of enforceable title provisions, which cannot be broadly interpreted. Instead, enforceable title status is only granted when the contractual relationship between the parties is clear and the obligations to be enforced are certain, liquid, and enforceable. Thank you for your attention.
Everyone, now we will be taking questions. I have my own questions. If there is anyone in the room, can you please help me? Madame Nathalie Frisseron, Madame le Professeur. Of course. Madame la Professeure.
Merci beaucoup. Je peux poser la question en français?
Thank you. Can I ask the question in French? It's easier for me. I think that the last presentation was extraordinary because in France, well, we do not have an analogous system. There is no executory title which is recorded in the fiscal administration. In litigations related to the payment of rents, we have to appeal to a judge. I have two questions. Why your law allows, which is the object that your law has an executory title? And the second question? Can this be contested by the person who rents the house? The legislator wanted that the creditor has the measures in order to solve the situation faster. And in the second question, there is the contestation qui est
Et l'article 905, je l'avais noté, applicarea de penalitati,
Ouais, ouais, ouais.
Est-ce qu'on peut considérer que c'est l'astreinte?
Mais c'est les obligations de faire qui ne se peuvent pas exécuter par d'autres personnes. Sont les obligations pour personnel. Le 905, sont les obligations pour personnel. Les pénalités sont seulement pour exécuter les obligations qui ne se peuvent pas exécuter par autre personne, par tiers ou par le créditeur lui-même.
D'accord. Est-ce qu'on peut considérer que ça correspond à l'astreinte en France?
Oui, c'est l'astreinte. C'est l'astreinte ou la d'Ashgon de Pays-Bas. En Pays-Bas, c'est d'Ashgon. En France, c'est l'astreinte qui est en mesure plus similaire. Plus similaire.
D'accord, merci. Molto mesque.
Con piacere.
I happen to have my own question. It's for our colleague, Cristina Dutzer. Regarding your paper, I would like to ask you, how would you address the main issue of maintenance responsibility and emergency maintenance repairs with regard to the question of qualifying emergency and the action needed to ensure any kind of repair without the consent of the owner?
Locative repairs, réparation locative.
With regard to lease agreements, right? When you have a lease agreement, you need to take into account emergency repairs and the problem of maintenance responsibility, yeah, and the problem of qualifying what constitutes an emergency, of course, and what action is needed for performing repairs without the consent of the owner.
Yes. I'll take the answer in English because the question was in English. So, yes. So the owner, in case of my colleague Anthony wasn't very specific which repairs he means. If are the locative or the capital, the capital ones, because the capital ones are meant to be dealt by the owner, the landlord, and the locatives one by the leaser. So I'm assuming that you mean the locatives. Emergencies, yes. In case of emergencies, the landlord, if they are capital, needs to deal with those reparation, but the qualification of an emergency, yes. If you have I don't know what to say in English. Țeavă care se sparge.
Pipe that breaks.
A pipe English. If in case of a pipe who breaks, for instance, tenant, yes. The tenant has the possibility to make the reparations. I think this case is one of those. The reparations are urgent. In civil code, it's permitted for the tenant to make those reparations and afterwards pretend the expensive to the landlord. We have a regulation in the civil code that permits the tenant to make that kind of reparation and afterwards demand the expenses to the owner. Yes.
in the civil code, there's no definition. Of course, we have to appreciate from case to case. From case to case. The judge will based on the emergency of the reparation. You are very attentive with my time. Thank you for all the others' time. And thank you for your question.
Okay, we will leave that to be answered by someone else. I think we have also another question.
Yes, hello. Risto Sepp, bailiff from Estonia. First of all, I'm impressed. I'm the only one who doesn't speak French. My question is to Christina. You, lovely presentation, thank you, by the way. Perhaps I misunderstood, but I understood by your presentation that the lease agreement is considered to be as an enforceable title for the eviction as well. Did I understood correctly, or do you need to follow the court resolution in order to make the eviction? Thank you.
It depends on the case. You understood correctly. If we have a lease, I'll take it in French, aux durée déterminée, à l'expiration du durée du contrat, à l'expiration du durée, à l'échéance.
If there, in the case of a rent, when the contract expires, but if the other obligations are not respected, as in the case of the usage, they have to address to the court in order to terminate the contract, and the judge has to decide. If we talk about the expiration of the date for the execution of the contract, this is an executory title.
Ziua, distinși colegi. Bonjour, très distingués collègues. Good afternoon, very distinguished colleagues. Je vais m'adresser d'abord en français parce que les conférenciers de ce groupe de discussion vont tous présenter en anglais, et pour assurer un équilibre entre les deux langues et aussi.
First talk in English because all the other presenters will talk in. Je vais présenter. I will talk in French because the other presenters will present in English, and I want to establish a balance. Allow me to thank the colleague and to congratulate them. I want to congratulate Professor Frédéric Ferrand, who is an exceptional professor, who has received a very honorable title today. You are an example for us, and I want to follow your example. I also want to tell you that I am very honored to chair this panel, number 3. This panel will deal with enforceable titles, and will tackle some examples in this regard. Each presenter will have 10 minutes. and that's why I kindly ask them to summarize their presentations and to present their general ideas. And at the end of the conference, we also have time for questions and other discussions. I hope that you will enjoy this voyage dealing with enforceable titles, examples in civil law, in administrative law, in criminal law, and in the end with issues dealing with arbitrage. The sailors of this voyage should have been 5. However, one of the presenters could not be able to come today. Therefore, we'll have only 4 presenters today. Lawyer Isabella Delia Popa could not come today. I want to thank to the team of translators who will try, and I know that it's very difficult to translate, especially when it comes to the teachers who talk sometimes too much. And I want to thank them before initiating this presentation session. Thank you.
Et maintenant, on va commencer.
We will begin our presentations. I invite Mr. Anthony Murphy, who will present a paper entitled "Enforcing a Judgment Debt Against Property Wrongly Included in a Certificate of Succession," together with his co-author Mircea Dan Bokshan. Mr. Anthony Murphy will present the paper in his co-author's name as well.
Ask you to have the floor and also to respect the 10 minutes. Thank you. Good luck.
Thank you very much. I'll try just to...
I didn't want it to extend the presentation because you already know him. It's a very well-known and reputed organizer of this event. And he doesn't need any presentation more. Thank you.
Thank you very much. I'm trying to check our presentation. I'm not really sure where it is. Should be here. Okay, so this is the presentation. I think we can start. All right. So, our presentation deals with a very peculiar case of enforcing a judgment debt against a debtor who was awarded full ownership, sole ownership of the marital home, yet a half share of that is of the said property mistakenly passed on to his daughter upon the death of his spouse. Now, let me start with a brief account of the case. Here is the timeline of the litigation. So, on 30 June 2014, 2 people signed a pre-contract. They entered a pre-contract agreeing that a sale contract will be concluded on the 15th of August 2014. The reason for the delay was that the prospective seller did not have his ownership registered in the land registry. he allegedly needed time to ensure registration. Well, the prospective buyer, in anticipation of the conclusion of said contract, paid the full amount on the 2nd of July 2014. But on the 12th of August 2014, 3 days before the promised contract should have been concluded, the prospective seller signed a unilateral declaration, notarized declaration, postponing the date for concluding the contract to 30 January 2015. For the reason that he failed to disclose the property was also owned by his wife, his ailing wife, who was suffering at the time of Alzheimer's disease. Well, he needed time to ensure the appointment of a curator, of course. But the date passed, another year passed. On 29 June 2017, not only was the contract not concluded with the prospective buyer, but with a third party. All right? Seeing this, the prospective buyer started a series of long litigations. A final decision was reached on 20 February 2019, which terminated said pre-contract and ordered him to pay back the money he received as payment for the pre-contract, for the conclusion of a contract he can no longer conclude. Of course, the debtor failed to comply with this obligation as well. The creditor turned to a judicial officer seeking to enforce said court decision. Well, seeking to enforce said court decision, the judicial officer managed to identify the assets of the prospective seller, which consisted of a home, the marital home, I mean the house and the adjoining land, as well as a state pension. Well, the house was in the ownership of the debtor and his spouse. Seeking to enforce said decision, the creditor obtained another court decision awarding full ownership to the debtor, with, of course, the obligation to reimburse his spouse's share in the marital home. However, the decision was appealed. On 16 March 2022, a notary public is requested to settle the late spouse's estate. She unfortunately passed away from complications from Alzheimer's disease. Of course, the decision by which the surviving spouse was awarded full ownership hadn't become final yet. So they went to a notary public who agreed to settle the estate. But on 24 March 2022, the appeal was rejected and the court decision became final. A few days later, on 8 April 2022, unaware of said decision, the notary public issues a certificate of succession granting half of the marital home to their daughter. Okay, so we have a final court decision awarding, granting full ownership of a house to the debtor, and a certificate of succession awarding half of that home to the daughter of the debtor. How do we enforce his debt if he owns a house but he doesn't own the house? It's some kind of, it's really similar to Schrodinger's cat, but in terms of property. It's a really complicated thingy here. In our view, the possible solutions are two and may be found in the Civil Code and in law number 36 of 1995, governing the notary publics and the notarial activity. The two solutions consist of rectification and annulment. Now, rectification is quite simple to understand. It requires two steps be ensured. You need to secure the consent of the parties, okay? But the parties must agree to rectify the flawed notarial instrument. In our case, it's really hard to think they would agree to do that, because their interest was obviously to not do that in the first place. The flawed instrument must allow correction. In our case, we have a certificate of succession which deals with the rights of heirs. When we have the rights of heirs, we no longer have minor inconsequential errors. We deal with rights, with subjective rights, with estate rights, real estate rights. When we deal with real estate rights which are put into question, rectification is not applicable. That takes us to annulment. Annulment may be achieved either in court or in the notary's office. In court, it's quite simple. The final court decision will serve as basis for the new certificate of succession. However, if we want to go just to the notary public, we need to have an amicable settlement which must be instrumented in an authenticated act, not notarized act, okay? But in both cases, the debtor is unlikely either to apply for annulment in court or to agree to an amicable settlement. This takes us to a very good question. If the debtor is unwilling to do so, is anyone else in right to apply for annulment? Well, in my view, consider that the legal provisions recognize this right to anyone whose rights were breached by the certificate of succession. Under a broad interpretation, we might consider that even the creditor may directly lodge a complaint. But that is not really necessary. The creditor may still apply for annulment under an oblique action. Okay, when the creditor exercises the debtor's rights if his neglect or refusal to do so inflicts damage. All right? So, in conclusion, I was really brief, not to breach the time limit. In our view, annulment is the only legal remedy for this conundrum. Unfortunately, the creditor is facing yet another uphill legal battle for what is rightfully his. Thank you very much for your attention.
Thank you very much, Anthony. Our next speaker is Mr. Mihai Udroiu, who is Associated Professor within the Faculty of Law, University of Oradea. And starting from October 15, he will be a judge at the High Court of Cassation and Justice. And I would kindly want to congratulate him for this success, giving him the floor. He will speak about the authority of the final civil judgment in criminal proceeding. You have the floor, Mihai, and the rule is maintained to stick to 10 minutes. Thank you.
Thank you very much. I tried to summarize my presentation in 7 minutes with 3 conclusions on the authority of the final judgment in criminal proceedings. In the first part, I want to emphasize that the victim of the criminal offense may seek indemnification for damages resulting from the illicit conduct through a civil lawsuits, initiating against the perpetrator civil action or a civil trial. So, in this context, we have to settle 3 main ideas. The first idea is that we have to analyze the potential effect of that might arise in the pending criminal trial based on the final judgment of civil court, particularly in the respect of civil indemnification of the victim before the criminal trial. In the second main idea is that concern the preliminary matter. And concerning the preliminary matter, it should be noted that the evolution of fundamental rights of a fair trial with implied guarantee of legal security. In this context, I want to take the attention for the situation in which also the dispute is settled by non-criminal courts. It is one that starts under the application of electa una via non datur recursum ad alteram. The final decision of the civil courts has res judicata authority that must be taken in consideration by the criminal courts in the context that concern the preliminary matter. And the third main idea is that that concern the coherence of the current criminal system after the relevant decision of the Constitutional Court number 102 from 2021. So, in this framework, I want to make some comments on the effect of the final findings of a criminal court on the claim for damages compensation related to the deed adjudicated in the criminal trial. According to Article 28, Paragraph 2 of the Criminal Procedure Code, the final sentence of the civil court ruling on the civil action does not have the res judicata authority before the criminal law enforcement authorities regarding three elements: the existence of the crime conduct, the person who committed the crime, and the guilt of the person who is accused of committing a crime. So, if we analyze the main core of the Article 28, Paragraph 2 from the Criminal Procedure Code, in my view, the legal provision should be structured in the extent that although the civil courts have found the existence of an illicit conduct and the criminal offense and the guilt of perpetrator is established according to the criminal code, we still have the possibility as a criminal courts to analyze the final decision of the civil court in the following sense. I can give you three main targets of the criminal analysis, but I will start with the most important of these, which concern the conduct for which the defendant is charged in the criminal trial in the context in which the criminal court does not agree with the judgment of the civil court, and the criminal court make debate in the matter of standard of proof. So, the criminal court can notice that the civil court has failed to meet the analysis of standard of proof beyond reasonable doubt, which is specific to criminal trial, and the criminal court can constate that, can notice that the fact that is the main object of the criminal action does not exist. And this is possible because apart from criminal court, in Romanian civil procedure, the civil courts does not have in establishing of facts a standard, a higher standard of proof like in criminal matters that the criminal courts deal with the standard of proof beyond reasonable doubt. So in this context, having in mind that in Romanian civil procedure has in fact does not have a free standard of proofs, we can notice that the higher standard that is used by the criminal court can conduct the criminal court to the conclusion that the guilt has not been proved at the standard of proof beyond reasonable doubt. This is why the criminal court may overrule the arguments of the civil court regarding the existence of the illicit conduct. On the other hand, if the evidence gathered in the criminal trial provides no further information regarding a different extent of the damage than that determined by the civil court, the criminal court may concur to the damage assessment given by the civil court. Likewise, in the line with the conventional standard for ensuring right to a fair trial, Article 28, Paragraph 2 from the Criminal Procedure Code will be applicable only to the extent that civil courts has not finally ruled on the lawfulness of the illicit conduct for which the defendant is charged in the criminal trial. The case law of the European Court of Human Rights, and I refer to the case Lungu versus Romania, has a significant effect in the analyzing of the effects of the civil court's ruling on the preliminary matters. According to Article 52, Paragraph 3 of the Criminal Procedure Code, the final decision of the other courts of law regarding a preliminary matter in the criminal process do have res judicata authority for the criminal trial court. The current content of the Article 52, Paragraph 3 of the Criminal Procedure Code has been amended by law number 201 from 2023, which found that the wording "except for the circumstances regarding the existence of the offense" under the provision of Article 52, Paragraph 3 of the Criminal Procedure Code to be unconstitutional. I don't want to make more consideration about the decision of the Constitutional Court, which in fact does not have a coherent idea and a coherent distinction between res judicata authority and double jeopardy guarantees. But I want to make some comments of the interpretation that can be made of Article 28, Paragraph 2 and 52, Paragraph 3. So, following the statutory amendment and beyond the limits imposed by Article 28, Paragraph 2 of Criminal Procedure Code, it should be remarked that Article 52, Paragraph 3 of the Criminal Procedure Code provides that other final civil judgment do have authority in the criminal process when it rules on preliminary matters, being binding even when the findings of the fact concern the actus reus and mens rea legal substantive standards to comply with in order to consider the defendant guilty or to be acquitted. More 2 minutes, isn't it?
1 minute from now on.
Okay. So, I'll take the conclusion. Three conclusions, as I understand that in half a minute. Unfortunately, one of the shortcomings for the legislative changes made in the last 9 years of the Criminal Procedure Code reveals a chronic lack of legislative cohesion. Second, on the one side, the legislator effort to transpose in 2023 the decision of the Constitutional Court is meritorious, but however, the legislative amendment has not followed by a coherent reframe of the provision of Article 28, Paragraph 2 of the Criminal Procedure Code. And third, we also note that the incongruence of the statutory provision regarding the effects of the final ruling of the civil courts may have in the criminal trial, the potential to lead to findings that cannot be reconciliated and sometimes may bring into the light even the double jeopardy doctrine, moreover in the context of civil and criminal law divide. Thank you very much.
Take your seat. Thank you very much. The third topic was supposed to be held also by a team composed by one of my colleagues, Professor Virginia Vedinaș, within the Faculty of Law, University of Bucharest, and Associated Professor Flavia Ghencea, within the Faculty of Law and Administrative Science, University Ovidius from Constanța. Unfortunately, Professor Vedinaș was also in a sort of objective impossibility to travel to Constanța, So she gave mandate to Flavia Ghencea to represent her and to speak us in 10 minutes sharp about special features of the enforcement of decisions pronounced by administrative litigation courts. Flavia, you have the floor. Thank you.
Thank you. Just a moment to put the presentation that I prepared. This is not mine. Okay, first of all, I want to say something about myself, maybe in the beginning. As our moderator said before, the study that I will present, it was conducted together and it was realized together with my professor, my former professor in the doctorate program, many years ago, yes, but we still remain in a very beautiful and fulfilled relationship over the year. My professor, Virginia Vedinaș, is a very recognized personality in public law in Romania. I'm just a little girl. Always I will be just a little girl. So, my professor has a very deep experience also in academic area, in theoretical area, but even in practice. She's a very good practitioner. She's a very good experience in administration. From my part, I am an associate professor at Ovidius University in Constanța. My main interest is in around public law, especially administrative law. So for this field, the enforcement procedure is not, we not usually use it in all the time, but we use as a tool, but not in the main area. What I want to say is because in the end, all the decision of even of specialized administrative litigation court sometimes are not always enforced voluntarily, so many times we end up resorting to the forced execution procedure. We propose today, and we prepare today a brief presentation of some special feature of the execution of the decisions pronounced by the administrative litigation court. Why this? Because in this field of enforced procedure, we have two different procedures, if I can say this. We have two different procedures. Differences comes first from the authority who give the act, and after that, the procedure in front of court. Always, like in old area of law, even in administrative litigation, a risk is always potential, and its potential is fueled, we told, by several aspects. And we think about one of them, thinking of specificity of the holder of the performance obligation, the public authority. In this context, we note the fact that those who are meant to enforce such a decision are the public authorities who, not infrequently, so almost many times, persist in the attitude by which they refuse to satisfy specific requests of individuals, and the loss of a lawsuit in an opportunity to fit such an attitude. So we can have this situation. Another point of view is from the fiscal administrative litigation, when numerous decisions impose the obligation to pay certain sums of money that determine following the control activity carried out by the specialized body, such as in Romania, we can mention Court of Accounts and some specialized structure from the Ministry of Finance. The established amounts are difficult to bear because these amounts mainly are often too high. Yes, their level is too high, or it involves specific administration procedures stretching over time, such as budget correction or similar ones. So a very long time. And from other point of view, the difference in legal situations between the solution the court can give. And in this point, we say that imposing the authority to fulfill a personal fact, obliging to issue or to adopt an act, yes, in the execution of the prerogative of public power, this is the obligation to do. On the other hand, obliging the authority to pay sums of money with or without compensation. So, just shortly, we have two main regulations in the enforcement procedure in administrative litigation, who refers a special law of the administrative litigation, and we have some regulation, some provision of the Code of Civil Procedure. The special law of administrative litigation provides that final court decision pronounced according to this law are enforceable title. So, according to the administrative law litigation, all the final court decision are enforceable title. The notion of enforceable title is defined by the Code of Civil Procedure, according to which are enforceable title executive decision provided by Article 633, judgments with provisional execution, definitive judgments, as well as any other judgments or document that, according to the law, can be enforced. So we have two regulations, two different different regulation, or one in compensation, the other. So we can conclude, we can say at this moment that those judgments, we can say that the judgments of the court on fourth instance that were not challenged with an appeal, or the appeal was rejected, as well as the judgment of the courts of appeal by which it was resolved, are enforceable title, the substance of the administrative litigation case. And all court decisions pronounced by administrative litigation courts represent enforceable titles, regardless of whether they refer to unilateral, individual, or normative administrative acts, or to administrative contracts. So we can make a discussion about the type of the administrative act. I must have to finish in minutes, said my professor. Oh, no, 20 seconds, okay. The final conclusion. Okay. I have a question, so it could be a question. All decisions rendered in administrative litigation are subject to the special procedure established by administrative litigation law, or only some of them? Yes, because we have two different regulations. And the answer can be, decisions are subject to this procedure only in the situation where the public authority is obliged to conclude, replace, or modify the administrative act, or another document, or carry out certain administrative operation. I can refer, but you can see in the written paper who will be extended with some jurisprudence and cases. And as a conclusion, I want to say there are subject to the special procedure regulated by the law on administrative records. The decision include obligation to do, the execution of which rests with the public authority from which the harmful act emanates, in its typical or assimilated form. And finally, judgment that were pronounced in action that had a different object, such as, for example, the payment of compensation, are resolved according to common law. I will stop here, and we can discuss more. And otherwise, thank you for your attention. Thank you, my colleague, and thank you, my moderator.
Thank you very much, Flavia. Maybe you will answer the question that you put to the audience today. The last, but not the least, I will give the floor to Gabriel Marcel Mihai, who is a professor within the Faculty of Law and Administrative Science, University Ovidius of Constanța, and at the same time lawyer, yeah, at the Constanța bar. And
arbitrator at the Commercial and Maritime Arbitration Court.
Well, a triple quality. I'm sure that your presentation entitled the Arbitral Award as an enforceable title will let us without breath and voice. I wish you good luck. You have the floor. Please.
Has a connection with the activity of arbitrator and the lawyer also. My conference lecture will briefly present the main aspects that shape the enforceability profile of an arbitral award. The existence of an arbitral title is a sine qua non condition for accomplishing forced execution. According to the Romanian law, Article 635 Civil Procedure Code, among the acts that have the character of an enforceable title are also the arbitral awards. Regarding certain effects, the arbitral award is assimilated by law with a court decision. Article 606, Chapter 4, Title 4, Book 4 of the Code of Civil Procedure provides that the arbitral award communicated to the parties is final and binding and shall be enforced by the party against whom it was rented immediately or within the time limit specified in the award. The essential difference between an arbitral award and the court decision is that the former is binding by express statement of the law. The arbitral award is a jurisdictional act which from the moment of its pronouncement became res judicata without any further formality. From the moment of its communication to the parties, the arbitral award has the effects of the final judgment. From the moment of its investment, the arbitral award constitutes an enforceable title and is being enforced just like a court decision. If its provisions are not enforced voluntarily, the interested party may proceed to enforcement. In this context, according to Article 615, Paragraph 1, Civil Procedure Code, an arbitral award constitutes an enforceable title ex lege only after it has been invested, enforceable by the court in whose district the arbitration took place, and then is enforced in the same way as a court decision, which means that the forced execution will follow the common regime of the law. The legal norm established on enforceability title of all arbitral awards, regardless of the field of arbitration: commercial arbitration, international commercial arbitration, maritime arbitration, arbitration for alternative dispute resolution on consumer protection. Until the arbitration award becomes enforceable, it is a juridical act with the force of a private document. Unlike a judge, the arbitrator does not have the power to order the enforcement of the arbitration award, nor does he has the right to empower and order administrative and law enforcement officials to enforce the award. This power belongs exclusively to the judge by virtue of the power of imperium conferred by the law. Unlike the final court judgment, which as a rule is enforceable by itself, proprio vigore, an arbitral award is enforceable and becomes enforceable only after it has been declared enforceable by the court. The enforceability of the final court decision is inherent, and it's become apparent through the issuance of an order for informants. In the case of the arbitral award, the enforceable force does not exist and is a matter of virtuality. The arbitral award becomes enforceable from the date of its communication and can be enforced even if an action for annulment is brought against the arbitral award invested as enforceable, since the mere exercise of such a remedy of law does not lead to the suspension of enforcement. Article 635 Civil Procedure Code. If the action of annulment is admitted after the moment when the enforcement of the arbitral award was carried out, given the applicability of the provision of the ordinary law regime, the interested party has the possibility to request the reverse of the forced execution under the terms of Article 723, 726 of Civil Procedure Code. A special situation inserted in the Civil Procedure Code is regulated by Article 603, paragraph 3, and concerns the case of where the arbitral award relates to a dispute concerning the transfer of ownership and the establishment of another right in rem over an immovable property. In this case, if the arbitral award is to be enforced, it must be declarative force and verified of compliance of the conditions and fulfillment of the procedure required by the law, will carried out by the court within the frame of the procedure of granting enforcement. For short, in the practice of international trade relations, the parties, in many cases, even in arbitration's agreement, that the arbitration award is to be rented will be binding and will enforce at will, willingly, not by the judicial, yes. This is the philosophy of arbitration. And the difference, yes. In maritime arbitration, under the rules of New York Court of Maritime Arbitration, if a party fails to perform its obligation under the award voluntarily, the other party may apply the Court of Justice for confirmation and enforcement. So in Tokyo, in TOMAC, Tokyo Maritime Arbitration Commission has the same rules. Finally, the 1958 New York Convention assimilate foreign arbitration awards to foreign judgment. The exequatur procedure is subject to the law of the states where the arbitral award is invoked, with the specification that no stringent condition will be imposed, nor will the court cost be higher than those imposed for the recognition and enforced national arbitration awards. For enforcement, foreign arbitration awards must meet the conditions of international regularity to be susceptible to enforcement, as says Article 4, Paragraph 5 of the Convention. Thank you very much for the attention.
Thank you very much. Permettez-moi de féliciter maintenant tous mes collègues qui vraiment ont respecté les 10 minutes et comme ça nous avons récupéré en fait le retard.
I want to congratulate the colleagues who respected the 10 minutes presentations, the timelines, and we have recuperated the delay. Are there any questions? We'll try to conclude in one phrase the topic of the presentations. If you want, you can summarize your presentations in one phrase.
Should account for the complications and the conundrum which I presented to you earlier, with regard to the conflict between the certificate of succession and the final court decision. And in that particular case, annulment is the best option. It's a real case. It's a real case. It's still an ongoing legal battle. They applied for annulment, and we are waiting for the result. Thank you.
For the protection of right of a fair trial, I think that the two main principles, the res judicata and the protection of double jeopardy, is enhanced only if we give the right proportion of the authority of the final civil judgment in criminal proceedings.
I don't know what conclusion to put now. For this moment, I want to thank you all to being here and to stay together, and hoping a lot to see next year or maybe sooner than that. Thank you.
I want to remark the utility of this conference, the theme of this conference. As a lawyer, as it was said before, we are confronting with a procedure, a civil procedure, a panel procedure, unflexible and very hard to make our defense strategies. I hope this conference, the theme of this conference, will help to get a more flexible procedure.
Mulțumesc, așa cum am promis, am să închei în limba română.
Thank you. As I promised, I will finish in Romanian because I want to congratulate once again the speakers from the panel that I have coordinated. I am professor and practitioner And as you have noticed, they were they were also professionals because they respected the timelines. And I want to conclude this session by thanking on my behalf, and I think that on behalf of the other presenters as well. I would like to thank the Dean of the Faculty of Law and Administrative Sciences of Ovidius University of Constanța, because he made possible this meeting, this exchange of experience. And because I want to thank to his professionalism and to his passion and to his dedication to the organization of this conference together with his team. And I want to thank him that during this period he made us feel comfortable, to feel at ease, and to make this legal exchange of experience, and also to socialize, to make an intercultural exchange, and also to exchange ideas as far as the law in general is concerned. I want to congratulate once again, and please applaud for Dean Adrian Stoica and his team. I wish you good luck. I wish good luck to the colleagues who will present their papers tomorrow, and please enjoy this beautiful autumn day, and please enjoy the Black Sea, because in my opinion there is no sand and sea as beautiful as the Black Sea today in Constanța. Thank you, and good afternoon, everybody.
So it's the last panel of the first day of the conference, and it's an honor for me to present the first team, which is composed by Mariana Mitraniță. It's an associate professor at the Faculty of Law and Administrative Sciences within Ovidius University of Constanța. Is the vice president of the National Association of Young Lawyers from Romania, the Constanța branch. It's a lawyer in the Constanța Bar Association, and together with our colleague, the associate professor Marilena Marin, who is the president of the Europrof Foundation of Lawyers from the Constanța Bar Association, and also a member of the council of the Constanța Bar Association. They made a paper together with Professor Vasile Drăghici, who is the chief prosecutor of the criminal prosecution section, prosecutor's office of Constanța Court of Appeal. It's a nice theme regarding the solemnity of the act of justice throughout history. We don't want to forget our history. Guest of our from Florida, professor, earlier asked me about the history of Constanța and the history of our university. So also in these legal aspects, let's see which is the solemnity of the act of justice throughout history.
Thank you, my colleague. I'll present in French our research. Merci, Madame Professeur. Le titre de notre recherche est La solennité de l'acte de justice travers le temps. Et ma présentation concerne une vue diachronique sur la notion comprise.
Our paper undertakes an examination of the concept of solemnity in the context of judicial proceedings drawing from the historical development of legal principles and insights from the field of criminal sciences. This analysis commences with a hypothesis concerning the perception of the notion of solemnity and the specific implications, particularly from a terminological standpoint. Subsequently, we embark on an exploration of this notion from a historical perspective, identifying distinctive features and characteristics associated with each historical epoch. Additionally, we scrutinize the contemporary legal landscape, shedding light on instances where actions conducted within the realm of justice exceeded the permissible boundaries prescribed by the law. The concept of solemnity within the realm of judicial proceedings possesses a long-standing history with its root tracking back to antiquity, evolving with societal development. Since the dawn of history, individuals have recognized the imperative nature of establishing official procedures and ceremonies to secure accurate decisions that are accepted in various disputes and conflicts. The implementation of incorrect decisions would have constituted a deviation from the principles of justice and, at times, even undermined the integrity of the judicial process. History demonstrates that each nation has established specific rules regarding the solemnity of judicial proceedings, related to, when this concept is analyzed, the societal category to which the accused or injured party belongs, or their criminological profile. The solemnity of a judicial act can be examined from multiple perspectives, namely from the standpoint of the formalities surrounding the legal documents submitted for judgment, or the act subject to enforcement, as well as from the perspective of the addressing formulas used during the adjudication of the case. In the latter case, the solemnity of the judicial act pertains to the formulations through which the parties and their legal representatives address the court or the authorities vested by law with the execution of an enforceable title. In this second scenario, the solemnity of the judicial act pertains to the formulations employed by the parties and their authorized representatives when addressing the court or the authorities vested by law with the execution of an enforceable title. Furthermore, there are established formulas and linguistic boundaries that the parties and their representatives must adhere to their interactions with each other and in their relations with third parties involved in the judicial process. Among these perspectives, we have chosen to analyze, in the context of this paper, the solemnity of judicial proceedings through the lens of the relationship between the parties and the courts, particularly the appropriate conduct they must maintain in front of the proceeding judge. This analysis also extends to the second phase of civil proceedings, namely compulsory execution as nearly any unresolved exception from the initial phase. And this can have implications during the subsequent stage. Our work holds practical significance by examining the interaction of professional ethics and conduct as well as the analysis of the efficiency of the judicial procedure and the accuracy of the title subject to compulsory execution. From the perspective of scientific research methodology, this paper approaches the concept of the solemnity of the judicial act through the lens of legal history. It does so by conducting an analysis of each historical epoch and by considering the practices of certain societies that have distinguished themselves over time through their established rules. So, the legal content or definition of the offense. The use of insulting or obscene words or gestures likely to disrupt the court's proceedings by a person participating in or attending a procedure taking place before the court shall be punishable by imprisonment for a period ranging from 1 to 3 months or by a fine. Statement of motives. The violation of the solemnity of court proceedings finds its origins in the offense of contempt of judicial authorities, as stipulated in Article 272 of the Penal Code. In other perspectives, this offense is not entirely new, but rather has a strong counterpart in the Old Criminal Code under the offense of contempt of judicial authorities. Thus, it not only recalls this offense, but also expands upon its content. In certain opinions, Boroi, this represents a new offense that recalls retains some remnants of the offense of contempt of judicial authorities, in which insulting or obscene manifestations during a procedure conducted before the court are incriminated. Other authors specify that this offense does not have a counterpart in the former Penal Code, but only takes some elements from the offense of contempt of judicial authorities. However, in the statement of motives, the legislator specifies that this is a new incrimination, but that the incidence of transitional situations is not excluded, and the current law prevails. Thus, the Constitutional Court, through decision number 156 per 2015, establishes that depending on the manner of commission, the old offense can be found either in Article 278 or in the Articles 277 or 279 in the current Penal Code. Due to this approach, offensive acts directed at any person in the courtroom are penalized, whether they participate in the procedure or not, or when directed at the judge, prosecutor, or lawyer during the procedure. The offense cannot be committed by the presiding judge or a judge participating in the court hearing, because they have the status of a secondary passive subject in relation to the content of the incriminated acts. However, in the event that such acts are committed by a judge during the procedure, they will be held accountable for the offense of abusive behavior. So the new penal code in relation to the previous penal law of 1968. This offense initially had no counterpart in the previous penal code. Through Government Emergency Ordinance number 198 per 2008, a similar incrimination was introduced, but with significantly expanded content compared to the offense of violating the solemnity of court proceedings in the present code. The previous regulation not only encompassed the use of obscene words or insulting gestures, but also threatening words or gestures aimed at the physical integrity of a judge, prosecutor, or law enforcement officer, acts which, under the current regulation, constitute the elements of the offense of judicial contempt or single contempt, as the case may be. Currently, criminal activity must be carried out only in the presence of the court, but is no longer constitutional on committing the incriminating act against a judicial organ. The offense can be committed against any other person as long as the act committed undermines the solemnity of the court proceedings. A comparative examination of the incrimination texts in the old and new penal laws reveals that contempt of judicial authorities had a much broader scope compared to the incrimination in the current penal code. The element of continuity is the use of insulting or obscene words or gestures as a means of realizing the material element of the objective aspect. If a prosecutor uses expressions or gestures without addressing them to a specific person, thereby disrupting the court's proceedings, this offense can be attributed to them. For example, if a prosecutor tells pornographic jokes while being intoxicated or directs insults towards the government, and the act is likely to disrupt the court's proceedings, they will be held accountable not only for abusive behavior, but for the offense of violating the solemnity of court's proceedings. It is worth noting that an attorney can also commit this offense. These manifestations can be carried out directly or through means such as letters, messages, or any other methods capable of establishing a direct link between the perpetrator and the victim. So, conclusions. In contemporary times, the solemnity of the judicial process remains a vital aspect for the functioning of a society based on discipline and respect. Offenses against court proceedings represent a complex legal concept that pertains to criminal acts committed with the intent to draw attention and capture the interest of the public or the media. Thus, acts of violating the solemnity of court proceedings pose a serious threat to social order and public security. Their presence is both welcomed and necessary, considering the value of the societal interest protected by the criminalization of this conduct. Thank you for your attention.
On vous remercie pour cette présentation.
For this presentation, I invite
a special guest because it's an honor for us to have the judge of the High Court of Cassation and Justice and also an associate professor of the Faculty of Law of the University of Oradea. I give the floor to Mr. Mihail Udroiu to present the theme Civil Enforcement of the Assets Freezed in Criminal Process.
Thank you very much again. This panel is lighter because I don't have Mrs. Marcus to measure the time, so I'll take 15 minutes for my presentation. Thank you very much. For the introduction, I want to settle three main ideas. First, by freezing an asset, either movable or immovable, during the course of the criminal process, a temporary limitation of the rights in rem is put in place. Said assets may belong to the suspect, defendant, or in some instance to the person who bears civil liability along with the defendant, or even the third party. The second idea, the aim of the measure is to prevent that those assets are hidden, damaged, sold, or evaded, to guarantee the payment of the fine, legal expenses, or the damages to identify the victim of the offense, as well as to secure special and or extended confiscation as finally ordered by the criminal trial court. And the third, which concern the limits of the analysis that I will make, is that I have to focus on the freezing assets aimed to guarantee the final payment of the fine, the legal expenses, and the damage to identify the victim of the criminal process, or otherwise known in the scholarship as conservatory seizure. So I will not refer to the conservative measures that are known in the doctrine as a preventive measure, or the measure which concern the preservation of the proofs in criminal procedure law. The seizure view as a conservatory seizure can be initiated by one or more enforcement acts. Moreover, it is necessary to determine the effects of the seizure on the frozen assets and the impact of such effects on the civil enforcement proceedings. Two topics I will want to analyze in my speech. In essence, the detailed analysis will be published in the volume of the conference. The first is the establishment of the assets freeze of the conservatory nature and its effect. And the second, it will be the enforcing the seized assets under the private law. For the first topic, regardless whether they manifest as a seizure, attachments, or mortgage registration, the protective measure of conservatory nature aims to prevent diminution of the assets in the patrimony of the defendant or the civility responsible part, or their alienation in full during the criminal process until the court has issued its final decision or the execution of its provision regarding the penalty of fine, legal expenses, or the reparation of the damage. In essence, implementing such conservatory seizure reveals the need to fulfill the following three requirements. The first requirement is fumus commissi delicti. That means the existence of a pending criminal trial regarding a crime relative to which there is a reasonable suspicion that it has been committed. The second condition is called periculum in mora. That means the existence of the risk of insufficiency in respect with the financial resources of the suspect, the defendant, or the civility responsibility part, for which to obey the infliction rule by the court when its decision becomes final, as well as the risk of an action or inactivity likewise to diminish their patrimony. And the third condition is a proportionality condition, that the assets freezing must comply with the fair proportionality standard between the burden of property, right, and the purpose pursued by the imposition of the seizure. Also, the provision of Article 249 of the Criminal Procedure Code stipulates that by means of seizure, the execution of the penalty, of the fines, of the legal expenses, or the compensation of the damage is guaranteed. I believe that it should be taken into account that by means of the procedural device, a guarantee in the extent of civil law is neither established, any order of priority establishing but just a limitation to exercise some attributes of the right of ownership regarding freeze assets is generated. Briefly, the main consequence of the seizure is that the freezing of the assets, also the owner still maintains the ownership. He can no longer decide any acts of legal material disposition, and he is not able to encumber said assets anymore in order to preclude all those risks mentioned above. However, the initiation of such measure does not make the assets inalienable or unavailable. The second topic that I want to analyze is the enforcing of the seized assets under the private law. The perceptible nature of the seized goods is not incompatible with the asset freezing and the purpose of their establishment. Thus, by capitalizing on the assets that have not been made available, they are not removed from the power of the procedural measure under the condition in which the conservatory seizure will continue to exist in some criminal process for the purpose it was instituted, but it will carry over the sum of money resulting from the enforcement disposal initiated in the exercise of the substantive and procedural rights recognized by the civil law. The incohesive case law on the possibility of enforcing the seizure of assets led the Supreme Court to adopt two generally binding decisions as follows. The first decision, it was adopted in 2018, is the decision number 2 from 2018, the panel competent to judge the appeal in the interest of the law. And the High Court of Cassation considered that the existence of the criminal insurance seizure on the real estate of a natural or legal person does not suspend the foreclosure started by a mortgage creditor whose mortgage right on the same assets has become objectionably to the third parties prior to the establishment of the preventive measure in criminal process, and does not determine the nullity of the Enforcement Act subsequent to the establishment of the preventive measure in criminal process on the same assets. The second decision made by the High Court of Cassation, the panel competent for resolving legal issues in civil matters, in this decision, the High Court of Cassation established that the existence of a conservative measure established in criminal trial on the assets of a legal entity prior to the opening of the insolvency procedure, with a view to the special confiscation to repair the damage caused by the crime or to guarantee the execution of legal expenses. And the High Court of Cassation established three conclusions. This procedure does not suspend the liquidation procedure provided by the law number 85 from 2014 regarding the seized property, is not likely to make available the property on which the capitalization procedure was starting according to provision of the law 85 from 2014, and does not prevent the liquidation of assets carried out by the judicial liquidator in the exercise of the powers conferred by the law 85 from 2014, I mentioned that the law 85 from 2014 regard the insolvency prevention and insolvency procedures with the subsequent amendments and additions. Conclusion. The existence of the criminal trial in which a conservatory seizure was ordered should not deter the creditors to exercise their rights. Enforcing of an asset that had been frozen in a criminal proceeding does not entail the risk of facing a criminal charge for committing an offense or of evading the seizure. We advocate this because the procedural device of a seizure order is in the criminal process arrangements is neither grounded for suspending a civil enforcement procedure nor an obstacle to it. When a sold at a public action to the seized asset is transferred to the bidder and the balance of the price after the privileged creditors have been compensated shall legally replace the seizure asset. So, in conclusion, I think that the interconnection between civil law and criminal procedure law is more evident in this situation of civil enforcement of the assets freeze in the criminal process. And we also have to have in mind the conclusion from the last speech that I have in this conference, that the res judicata authority of the civil judgment has to be respected by the criminal courts in the even in the process of civil enforcement of the assets freeze in the criminal process. Thank you very much.
Thank you very much for your speech. It was a very interesting one. As a practitioner, we saw many cases in which these assets are, for a long period of time, freezed in the criminal process. Maybe it is good what Professor Leș said earlier. We need to think of the period of a trial that is longer in Romania nowadays, but we hope that this will improve in future. Now I will give the floor to Associate Professor Gabriel Grigore with the theme Enforcement of Obligations to Do or Not to Do, special focus on enforceable titles concerning minors. Mr. Grigore is a member of the board of the directors of the Lawyers Insurance House in Bucharest, the president of the Ethics Commission of Ovidius University of Constanța, and was between 2011 and 2018 the dean of the Constanța Bar Association and the member of the Council of National Union of Romanian Bar Association.
Thank you, Madalena. Well, it's late, and I will try to be briefly. I will present you a few considerations of the forced execution of obligations to do or not to do, and forced execution concerning minors. This debate on the forced execution of obligations to do or not to do, which represents an important component of the procedure of forced execution of enforceable titles, considering their specificity. In doctrine and jurisprudence, a distinction is made between the methods of execution available to the creditor, such as obligation to do, which can be performed by someone other than the debtor, and those that can only be executed by the debtor. Regarding the performance of the obligation to do, the creditor can always demand that the debtor be compelled to perform the obligation in kind in application of the civil law principle of the priority of performance in kind of the obligation, unless such performance is impossible. The legal provisions provide for the coercion of the debtor by regulating the principle of the application of some penalties, which, however, cannot be equivalent to the performance that could not be fulfilled by someone other than the debtor. A special feature in this matter is the execution of court decisions and other enforceable titles relating to minors. The rest of the obligation to perform generally cannot be enforced directly in kind. Article 1528 of the new Civil Code states that if an obligation to perform is not fulfilled, the creditor can perform it themselves or have it performed, but it does not allow the creditor to compel the debtor to perform it. As a result, the enforcement of obligations to perform can be done by the creditor themselves, enlisting a third party for execution through supplementary means of forced execution in kind for obligation to perform, such as penalties provided by the Code of Civil Procedure. The first option involved the creditor's ability to carry out the performance themselves and then seek reimbursement from the debtor. The second case involves the creditor enlisting a third party to perform on their behalf and then seeking reimbursement from the debtor. In practice, these two remedies are substituted and ultimately result in execution by equivalent. However, the new regulation includes this under the scope of forced execution in kind. The execution of obligation by the creditor or a third party is lawful because court authorization is not required for Article 1528 in function unless the debtor opposition necessitates judicial intervention. The only legal requirement is that the creditor must have notified the debtor of their intention to perform it themselves or have it performed by a third party. This notification can occur either at the time of default or subsequently. Regarding the obligation not to perform, it is duty of the debtor in a legal relationship to refrain from committing one or more specified acts or deeds. Fulfilling such a negative obligation does not require proof. It is the creditor's responsibility to prove, if necessary, the positive facts indicating a breach of the obligation. Although these remedies are generally included in the technique of creditor authorization, the legislator decided to regulate them separately, specifying that in the later case, the remedy has a judicial character. This provision is natural considering the gravity of rectifying what was done in violation of the obligation not to perform. Furthermore, the removal or rectification must be done at the debtor's expenses, with the debtor first being put in default. In contrast to the general enforcement framework, it is observed that the legislator, regarding the enforcement of enforceable titles stipulating obligations to perform that cannot be performed by a person other than the debtor and are not accessible in monetary terms, has established an exceptional situation mean to assist the obligated person. This allows for the possibility of eliminating or reducing the penalty imposed by the court through an enforcement contestation, acknowledging the debtor's ability to obtain such a relief if the obligation is performed and valid reasons for the delay are proven. One initial issue raised regarding this legal text concerns the finality of the ruling that established the late penalties. In this regard, the Constitutional Court of Romania has stated that the finality of this ruling is in full harmony with the legislative purpose of compelling of defaulting debtor to fulfill the obligations specified in an enforceable title, which only they can perform by applying a civil fine per day of delay until the execution date. By imposing this pecuniary constraint, The aim of the counteract abusive tactics aimed at delaying the fulfillment of the debtor's assumed obligation, thus ensuring the expeditious nature required for forced execution. In summary, as a general rule, forced execution enforcement should remain the last resort of an exceptional procedure to be used for the enforcement and enforceable titles, regardless of the subject matter of the enforcement. Especially in matters involving minors, it is desirable for forced execution to be the least frequently applied solutions, and the best interest of the child should not be used as an offensive weapon. It is the most vulnerable aspect of parent disputes. Starting with these sections, title referring to the forced execution concerning minors, it should be noted that the primary enforcement title generally is the court decision. However, court decisions can arise in various legal domains, such as civil, criminal, administrative, and fiscal matters, among others. Nevertheless, it is difficult to imagine a court decision in, for example, administrative or fiscal matters containing provision relating to minors. On the other hand, a court decision in a criminal matter may include provisions by the criminal court that affects minors when a parent is a criminal convicted. In such cases, the criminal court decision becomes an enforceable title supplementary to the principal criminal disposition. However, not only court decision can serve as enforceable title. With the introduction of the new civil code, the dissolution of marriage can be carried out either before a notary public or civil registry officer or through a court proceeding. Consequently, a divorce certificate issued by a notary public or civil registry officer becomes an enforceable title. To initiate the forced execution of enforceable titles related to minors, the creditors must follow standard procedure. The creditor will address the competent judicial executor either personally or through a legal representative submitting a request for forced execution. If the debtor does not comply with the summons, the judicial executor will refer the matter to the enforced court upon the creditor's record to impose penalties according to Article 906 of Civil Procedure Code. The time frame for forced execution of enforceable titles relating to minors follow the general rules stipulated by Civil Procedure Code. The execution will be carried out by the judicial executor in the presence of a representative of child protection and when deemed necessary, a psychologist appointed by them. The psychologist present is not required if the representative also holds qualification as a psychologist. Failure to comply with the provision concerning the presence of the directorate's representative result in the nullity of the execution. In cases involving parental alienation syndrome, where a child refused contact with the parent despite a court order, serious emotional abuse may occur. Alienation disrupts the child's rise to a healthy family life, damages their emotional bonds with the parent, and constitutes a form of child abuse by violating the rights relating to a parental authority or guardianship. Thank you.
Thank you very much. It was a very interesting presentation, and I was a witness as a lawyer to such a case in which even if the mother had a title to take the children and to care them through the divorce, the two children refused to go to the mothers, and the bailiff had to write that down in the process that he wrote, And nowadays, we have to take into consideration also the minor opinion, if they want to go or if they don't want to go. Of course, they will follow a tutorial with the psychologist and everything. This is another procedure, but even if we have a title and the child refuses, we cannot do in other ways. So we are living in different times. The bailiff also said that when we were there all together, mother, father, the lawyers, and everybody, and he had to take into consideration the minor, the opinion of the minors. So that is why I'm saying, even if we have a title by the Tribunal of Constanța, the mother couldn't put it into force. So this is what happens in real life. Thank you very much. It was the last panel. I think all the presentation attire some interest on behalf of you. We are very happy that you resisted until 5 o'clock in the afternoon. We wish you a wonderful evening on the Black Sea coast, to have maybe a walk along the beach. And we will see you tomorrow at 10 o'clock with new forces. Thank you very much.